Rise. Justices of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division. Go here, in your attendance, and you shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division, First Department. We have some 6 hours of argument this afternoon, so please keep that in mind as I call the calendar. Please also remember that we have your briefs, we have a record, and we are fully familiar with the facts of the case. So please ask only for the time that you actually and absolutely need when you give your time, okay? First case is People versus James Rizzo. 5, 2, and 5. Thank you. Ford versus Lee. 5, 2, and 5. Thank you. Dayona versus John is submitted. AK, an infant, versus New York City Health and Hospital Corp. 6 and 2 and 5. Perez versus New York City Civil Service. 5, 1, and 5. People versus Alexis Ocasio. 5, 1, and 5. A&L versus Jasper Hospitality. Submitted. People versus Monicha. Submitted. Personal Touch Home versus City of New York Human Rights. I'm sorry. Who do we have here? Okay, do you wish to submit? Okay, and submission. Thank you. Castle Point National versus Mount Holly.
I'll request 5-2, Your Honor.
5, 1, and 5.
5-2, Your Honor.
I'm giving you 5, 1, and 5. Thanks. People versus Alexis Ramos. Submitted. Sedum versus SUNY Downstate Medical. I'll give you 5, 1, and 5. People versus Van Din. 5, 1, and 5. People versus Brian Winston. 5, 1, and 5. Rank versus Rank. I grant the pro hoc vice and 6 and 2. 6, 2, and 5. People versus Robert Davis. 5 and 1 and 4. McMahon versus Cobblestone Lofts. 6, 1, and 5. Jandel versus 42 West 17th Street is submitted. Board of Managers versus Hazan is submitted. First case for argument is People versus Rizzo.
Good afternoon, Your Honors. Hunter Haney for Appellant James Rizzo. At multiple stages of the proceedings below, the trial prosecutor violated her duties of fair dealing and candor, depriving Mr. Rizzo of his constitutional rights to due process and a fair trial. The trial court should have granted a mistrial given the pervasive nature of the misconduct, which occurred at 3 distinct stages, the prejudice compounding at each stage. First, the trial prosecutor represented on numerous occasions prior to trial that there were only 2 incidents.
Okay, but with regard to what happened at the trial, because this is a trial, so what happened before the trial may have impacted one's belief about the purpose of the questioning, but the questioning and the answers is really all that what was limited to what the jury heard here. So what is it about the statements, and they were limited statements, that you feel entitles you to the mistrial?
Well, so the lead up to the question is actually what really underscores the prejudice of the question that the prosecutor asked. So
the prosecutor believed that she said she was mistaken. Obviously, if you're mistaken or if you're uncertain of something, the way to figure it out is certainly not during the cross-examination of the defendant, to whom you should have provided all the Brady ahead of time. But the questioning was limited, and the amount of information that came out, if you take the people at their word, was limited, wasn't it?
Well, absolutely not, Your Honor. I don't think this was a situation of mere isolated negligence here. And I think there are a few different reasons why that's the case. The subject of the second incident came up no shorter than 8 times prior to Mr. Rizzo actually taking the stand. And not once did the prosecutor even attempt to try to clarify the situation. We also know that it was intentional because the prosecutor actually admitted at page 170 of the minutes that she intentionally asked the question, despite many opportunities, again, beforehand to clarify the issue.
Counsel, did the court issue any kind of curative instruction to the jury in regards to those questions?
The court did issue a curative instruction to the jury, but this is exactly a circumstance where, as the court held as recently as last Thursday in People versus Challenger, a supplemental authority that we provided to the court.
But Challenger was a little bit more distinguishable. There, the testimony was bolstering. I mean, it was prejudicial bolstering there, right? I mean, that one was really went over the top. It had to do with in terms of identification.
This was even more prejudicial than the conduct at issue in Challenger because counsel had chosen, by the point that this question and answer occurred, to advance a multi-witness impeachment strategy in reliance on the prosecutor's repeated misrepresentations, and the prosecutor then proceeded with one question and answer to demolish the defense that the defense counsel had advanced over the course of the trial, as well as Mr. Rizzo's intoxication defense, which was his only remaining defense, in just that one question and answer. So at that point, the fairness of the trial was completely undermined, and the limiting instruction did nothing to really cure the error, especially where the court didn't even instruct in its instruction to the jury that the references to the earlier incident from the prior day's testimony from the other witnesses be disregarded. So this is even worse than the error in Challenger, where the court held that truly prejudicial evidence cannot be erased from jurors' minds by a limiting instruction. Counsel did argue that the prejudice could have been avoided entirely had the prosecutor simply met her
This case didn't turn on identification, though, did it?
It did not turn on identification. Okay. It was an intoxication defense, which is exactly what the question and answer entirely undermined, given that Mr. Rizzo had testified that he had been drinking between 2:30 and 4 p.m. prior to each incident. The revelation that there was an earlier incident completely undercut that sole remaining defense, that he only shoplifted when he was intoxicated. And then there's a third form of misconduct in this case, which is really crucial here, that I think underscores the intentionality of the prosecutor in this case, and that's the conceded Rosario violations for not turning over routine discovery materials, specifically the complaint report from the earlier incident, the evening incident, the store report from the 1 p.m. incident, and the 911 calls, all of which would have clarified, as counsel argued, that there was a second incident that day and fully prevented everything that had ultimately transpired. Those items are still undisclosed to this very day, despite numerous specific requests.
Thank
So
you.
the prejudice could not be cured and the court should reverse. Thank you.
Thank you.
I'm going to try my glasses without them fogging up. May it please the court, Melancha Chanda for the people. At the outset, the people want to make clear that we do not dispute there was a mistake made here. And
So was
trial-
this intentional or was it a mere mistake? Because it wasn't the first time the issue was brought up. It had been brought up repeatedly, as counsel said.
Excuse me, Your Honor. I think that what the record shows, and for the reason for an extended discussion of the record in the brief, was that she unfortunately remained confused throughout the course of the discussions with the court, and it really showed that she failed to appreciate that there were two distinct times, and she failed to investigate. That's admitted.
But why would
But-
you then try to clarify that with a defendant on the stand? The defendant is on the stand. Isn't the time to clarify whether something your officers told you was accurate
Because
before you questioned the defendant? I mean, wouldn't that be obvious that the prejudice would be great?
As the record shows, Your Honor, she still was laboring under the misapprehension that the officer was incorrect, because she had if you recall, at trial, her main witness for that, Tyler Goodridge, he was adamant there was a 9:30 incident. So she, I believe, through the course of it, was just still belaboring under the misapprehension that the officer was incorrect. And she said, she asked this question to clarify for the defendant and to find out why there could have been this discrepancy. I'm not saying that was the smartest move on her hand. I just don't think that it was intentional, as I believe that the trial court properly recognized, because the trial court held extensive discussions and it was in the best position to determine whether she acted on bad faith. And the court specifically said that it was not accusing her for that. And the record made that clear. And I do want to point out, Your Honor, that you mentioned, and this is very critical, that the end result of that mistake was a brief reference to an uncharged crime, and an indirect one too, before the jury. So while my opposing counsel focuses on all the extensive discussions and her maybe confusion, we really need to focus on what came before the jury. And it was an isolated reference that the court made sure to strike.
In fact, during cross-examination, there was no objection lodged to the question.
No, there wasn't, Your Honor. And actually, when he did not even admit that he had been there at that 1:30 incident, and then she moved on.
Let it go.
She didn't, yeah, there was no objection. She didn't pester him about that. And rather than the drastic remedy of a mistrial, the curative instruction, especially in this case, where, as I hope Your Honors have viewed the video, the evidence was compelling of guilt, and his intoxication defense was patently incredible.
Well, the other side is relying on this recent case that curative charge doesn't cure this problem here. What do you think of that?
And as I believe Your Honor has pointed out, that case is absolutely distinguishable. There was an ID issue in that case, which isn't here, where he's admitted he's the one on the tape. And I think I want to point out that I believe in the Levi Challenger case that effectively the officer was serving as the victim, because the victim couldn't have made that ID. So it was almost as if the officer's testimony was substituting for the ID that should have made by defendant, and that was much more harmful in that case. Here, you have him on videotape, you have him admitting that he's the one on the tape, and you see him committing the crimes of shoplifting / burglary in the third. So unless there are any other questions on the weight or the excessive sentence, I'll rest on our brief.
Thank you.
Thank you.
James Rizzo chose to go to trial and exercise his right to go to trial, to receive a fair trial on his intoxication defense. And that was entirely undermined here by the misconduct that took place. And it doesn't matter whether or not the conduct was intentional or an accident. One can, I think, easily divine a circumstance where such extremely negligent or reckless prosecutorial misconduct undercuts the fairness of a trial, and it really need not look further than this case to do so, because counsel was, again, totally misled into raising this defense. And the uncharged crime, however isolated it might have been, completely undermined the whole purpose for Mr. Rizzo going to trial in the first place, to assert his intoxication defense. And the trial prosecutors in this county know better, surely, than to not raise an issue like this if they have suspicions before actually going ahead and cross-examining on an uncharged crime. It's an elementary principle, and it truly undercut the defense.
Well, at the very least, she should have known better, or the prosecutor should have known better at the very least.
She should have known better, and under the cases cited in our reply at page 5, we need not show intentional misconduct to make out a claim such as this. If the prosecutor, as is shown in the record in this case, has been faced with the possibility that there might be a second incident, no short of 8 times this was brought up, and we list that again in our reply, she absolutely should have known better. And this is absolutely the type of case where the fairness of the trial was undercut.
Thank you.
Thank you.
Ford versus Lee.
May it please the court, David Bloom, Kaufman, Borges, and Ryan for the defendant appellant, Dr. Karen Lee. Good afternoon. Your Honors, regardless of when this plaintiff claims she first discovered the cancer, the action against Dr. Lee was time-barred, and it should have been dismissed for that reason based upon this 2018 amendment, which stated very clearly that Laverne's law shall apply to acts, omissions, or failures occurring within 2 years and 6 months prior to the effective date and not before. That's the key statutory language, which should have resulted in the dismissal of this case. And
Counsel, you just said regardless of, is there any dispute as to exactly when the malpractice was discovered?
no,
And that is, the date is what?
the cancer was discovered allegedly by the plaintiff on October 7th of 2019. The failure to diagnose cancer occurred allegedly on May 16th of 2014.
It's the diagnosis that's not a dispute. The diagnosis.
You mean the date of the diagnosis?
Date of the diagnosis that's not in dispute.
The date of the diagnosis is not in dispute.
That's May 14th, that's May 14th, May 16th,
16.
2014, right?
No, the failure, the alleged failure, the omission here, the alleged misdiagnosis occurred on May 16th, 2014, which was
2014.
well beyond the 2.5 years prior to the effective date of the statute, which was January 31st of 2018.
That's the retro portion. The way I read this statute is there are 2 classes. There's the retro portion and then there's the revival portion. And under the facts and the dates that we have here, it doesn't come in the retro or revival, because for revival, the statute of limitations ran in sometime in November of, I forget what date, November of 2016.
So 2.5 years on the malpractice claim from the alleged malpractice puts you at November 16th of 2016.
Right, and that's outside of that 10-month period for the revival.
Under the 2017 amendment, that's 100% correct. And Your Honor, I'm glad that you brought that up, because the 2017 amendment very clearly states that there is this grace period of 6 months from the effective date within which to bring suit for claims which became time barred within 10 months of the effective date under any applicable limitations period, quote, then in effect.
So if we use the November 16, 2016 date, or the May 16, 2014 date, we're still beyond. Is that correct?
That is correct, Your Honor, and I believe
According to your argument.
that's our position, Your Honor. No other court has ever held that the retroactive impact of the 2018 amendment does not apply to cases where plaintiff discovered her cancer after January 31st of
So it's really not, so it's not really, it's not, I mean, the 2017, the new law, the statute provides for discovery, but you don't get that discovery benefit unless you fall within the two classes of permissible malpractice claims, right? I mean, that's the problem here, because clearly the discovery was with, you know, if you assume that they fell within the class of the two classes, the statute of limitations doesn't, I mean, they get the benefit of the 2017 statute then, because of the discovery rule.
If it became time barred within 10 months prior to the effective date, then they're okay. But here, it doesn't fall
Right.
within the 2017 amendment, and the 2018 amendment, there's a clear cutoff date of July 31st of 2015, excuse me.
Let me just clarify this for myself, right? So it's time barred under a regular statute of limitations in November of 2016.
Correct.
And then it's not, it doesn't get that extra period because it didn't become time barred after March 31, 2017.
Correct. Under the
Okay.
2017
Got it.
amendment, I understand,
Got
yes.
it, right.
And now I understand
And the
what.
fact that she discovered it in 2018 doesn't mean that the statute doesn't apply. Okay, got it.
You know, our position is that regardless of when it was discovered or when she claims it was discovered.
So counsel, does your position comport with the legislative history of the statute?
It does, Your Honor, because when Laverne's law was first, when it became effective, right, it added subsections to 214A and 203G. However, initially, it did not address the revival of claims which were time barred under the pre-Laverne's law versions of the statute, all right? And as a result, that's why 2017, it was amended. That's why 2018, there was a cutoff date. May I have another minute, Your Honor? Or
Yeah.
I'm happy to wait until rebuttal, though. Your Honors, I would just say that the plaintiff's attempts to distinguish this case from the many others that I've cited, based on the fact that she allegedly discovered it after the effective date, essentially she's trying to assert that the post-Laverne's law limitations period should apply here. However, both the plaintiff and the lower court missed the point, which was that this action, the claims against Dr. Lee, were already time barred when Laverne's law took effect.
Thank you.
And that's why.
Thank you, counsel. I think
thank
you've
you.
gone over the answer to the question.
If it please Your Honor, the appellant refuses to look at the wording of 214A subdivision B I. The statute is to be given a clear reading of its words. The clear wording of that statute, 214A, under which the appellant moved to dismiss, specifically states that if the discovery of the malpractice, the cancer that was failed to be diagnosed, the plaintiff may have 2.5 years from the date of the discovery if it is after the effective date of 214A B subdivision I. Plaintiff clearly comes within the wording of the statute. Her discovery date of the cancer.
Counsel, then how do you distinguish the Second Department's decisions in Mckinnon and Mueller?
All of the cases cited by the appellant, the discovery was before the amendment of the statute.
Why is that relevant?
It's relevant because effective January 31st,
Does the statute say anything about the discovery has to be before or after the amendment of the statute? Does the statute say anything about that?
No, the
So
statute,
that's your interpretation, not anything that's in the statute.
it's the wording of the statute itself. Effective
It says in the statute that the discovery has to be after, that any discovery that's after the statute is automatically, regardless of when the malpractice took place, is automatically revised?
The provision is that the malpractice will be 7 years in the past. The
So then why
statute
would you even need that whole part of the statute that's talking about if it was, why would you even need the revival part if that's correct? There would be, that whole revival part would be superfluous.
The legislature passed 214A subdivision BI effective January 31st. The sponsors of 2018, the sponsors bill specifically indicated that they were changing the malpractice date of 2.5 years from the malpractice date to the discovery date.
But again, that would make that whole part of the revival provision superfluous. If all it was is you have to discover it after the statute applies and you can go back 7 years, then you wouldn't need to revive any time-barred claims.
The revival statutes apply to where the discovery was prior to the statute effective date of January 31st. 2018, all of the cases cited by the appellant had the discovery date before the amendment of 214A went into effect. In 4 of the cases cited by the appellant.
No, I'm not talking about the cases. I'm talking about why, if we interpret the statute the way that you're asking us to, why would you even need a revival period?
The statute is very clear. It says when the action is based upon the alleged negligent failure to diagnose cancer or malignant tumor, whether by act or omission, the action may be commenced within 2.5 years, 2 years, 6 months of the latter of either. And BI says when the person knows or reasonably should have known of such alleged negligent act or omission and knows or reasonably knows that such alleged negligent act or omission has caused injury. And then it indicates, goes on to say, provided that such action shall be commenced no later than 7 years from the alleged negligent act or omission.
No, I know what the statute says, but I still don't think that you've discussed why you would have to have a revival section if all it was is you can go back 7 years. If you discover 2.5 years, you wouldn't need to revive any claims. They'd all be revived.
All of the revised and revision provisions refer to where the discovery was prior to the amendment date. And those are the cases cited by the appellant, which are prior to the amendment date. And the dicta in 4 of those cases indicated that the discovery date was the new law. And they indicated that this was not the case when the revival statutes indicated it was prior to the amendment date. Thank you.
Thank you.
Your Honors, 2 quick points on rebuttal. First, applying the Laverne's law in the way that the lower court did and in the way that the plaintiff is asking this court to do would lead to harsh and unfair outcomes. And I would note that the plaintiff...
Well, is the plaintiff correct in indicating that there in section BI, there is this discovery when the plaintiff would have reasonably known or reasonably should have known that should apply to the statute of limitations, as how we're looking at it?
Your Honor, the statute says what the statute says, but what it doesn't say, what it does not include, is language addressing actions that were already time-barred when the statute went into effect. And that's the key distinction here. Plaintiff has offered no attempt to address this hypothetical scenario, which I raised in my brief, which shows just how flawed the lower court's reasoning is. I'm not going to rehash it. I think the court read my brief. And the second and final point I want to make is that, at a minimum, the lack of informed consent cause of action should be dismissed. This is, Laverne's law does not involve lack of informed consent. We asked for it in our motion papers, and we asked that at a minimum that claim be dismissed. And if there are no other questions, I'm happy to rest on my brief. Thank you.
AK and infant against New York City Health and Hospital Court.
Good afternoon, Your Honors. May it please the Court, Jonathan Popolo for Appellant, New York City Health and Hospitals. I'd like to focus my time today on causation, as it's the more clear-cut ground for reversal. Health and Hospitals experts, which included a pediatrician and a child neurologist, made a prima facie showing that the child's cerebral palsy could not have been caused, as plaintiff claims, by brain injury caused by lack of oxygen during labor and delivery. And in response to that, plaintiff's expert was unable to tie, the alleged instances of transient hypoxia during labor and delivery to the cerebral palsy that was discovered later on. And there were several factors that H&H experts relied upon that were just completely unaddressed and uncountered by plaintiff's expert. One of them was that there was an MRI taken about when the child was about 6 months old, the MRI that revealed the strokes, but it showed no white matter injury. And as H&H's expert explained, there would have been white matter injury that would have been present if the child had suffered a brain injury from lack of oxygen during labor and delivery. And that goes completely unrebutted. And it's relevant here that plaintiff's expert is an OBGYN, but does not have any expertise in pediatrics, neurology, has no experience that's set forth in his or her affirmation that there's experience in pediatric developmental disabilities. So,
Well, counsel, the plaintiff's expert does point to a different reason for the causation, right? The up and down of the fetal heart rate and the failure to perform a timely C-section based upon the deceleration of that fetal heart rate over the course of about a 12-hour labor. Why isn't that enough to raise at least a triable issue of fact?
well, I think whether a C-section should have been performed or not goes to whether there's a tribal issue of fact as departure. And I can circle back to that, but I agree that the stronger argument here is on causation. And the issue is that the causation element, the expert just doesn't have the right expertise and doesn't lay a foundation for it. Doesn't say that it has any, while maybe it has experience in when or when not to perform a cesarean section, he's not able to tie that in terms of proximate cause to the cerebral palsy that the child has. And the H&H experts who do have the relevant expertise listed a number of factors that ruled that out, primarily among them the MRI. And an interpretation of the MRI is well outside an OBGYN's area of expertise. Nothing in that expert's training or experience allows that expert to opine on the issue.
Is that something that we're deciding here, or is that something that can be argued in front of a jury so they can weigh the credibility of each expert?
No, I think this goes to baseline qualification. I think it's something you can decide. And also, I may have gotten ahead of myself a little bit here. I mean, it's not even a question here necessarily. You don't even really have to get to the qualifications issue because it wasn't even addressed. I mean, it might be a question if it were addressed, if the expert had said, no, that's not right about the MRI, then we'd be arguing about whether that expert had the right qualifications or not. I mean, this is sort of a, doubly, double error here in a sense because the plaintiff's expert didn't even address that point, didn't even refute it at all. And, there's an attempt in the respondent's brief to sort of clean up the deficiencies in their plaintiff's in plaintiff's expert's affirmation, but, a lawyer can't do that in a brief. I mean, apart from the, lack of preservation, there's certainly, they don't lack the qualifications to do that. They also didn't address, as one of H&H's neurologists pointed out, difference between respiratory and metabolic acidosis. Plaintiff's expert pointed to a mild respiratory acidosis, but
Counsel, just getting back to Justice Pitt's comment about that may be a departure, but you're saying that when the plaintiff's expert made that comment about the departure, you're saying that, yeah, okay, if we were to concede that, the causation link wasn't there. He didn't go one step further.
correct, Your Honor. I mean, I'm not conceding departure, but I am acknowledging that an OBGYN is, probably qualified to talk about whether a cesarean should be performed or not.
You're missing the other link, the
Correct.
causation aspect.
Yes. And that can't be fixed on appeal. And in terms of, just to transition briefly to departure with the little time I have left, I think on departure, it's an issue of you can't work backwards from an injury to find a departure. I mean, there's sort of a kind of classic Monday morning quarterbacking aspect to this, that you go through and you look at, there were transient decelerations in the fetal heart rate, and our experts explained why those didn't warrant an immediate cesarean, and there's just sort of a rather conclusory argument from plaintiff's expert that's saying, I say a cesarean should have been done, without explaining why what was done isn't just simply a difference of opinion, which between physicians was isn't enough, but was actually a departure from a accepted standard of care. And I'll reserve the rest of my time for rebuttal.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent in this appeal. Let me start from the beginning, and then I'll try to deal with the causation issue and the departure issue as well. The basic theory of the case, and something that wasn't mentioned in my adversary's argument, is the nature of this birth. 36 weeks gestational, preeclampsia, with a plaintiff who admittedly is not compliant with respect to diabetes. Okay, that's an understatement. The expert's hypothesis is extremely logical, extremely smart, and in accordance with medicine. Just like a defendant takes the plaintiff as he finds them, doctors, lawyers, professionals take their clients as they find them. She was high risk from day one because the environment that the baby was in was a toxic environment based upon her pre-existing conditions. And the expert's hypothesis is very simple. Once there's any evidence of fetal compromise whatsoever, take the baby out. There's no question if you look at the...
Well, let me ask you this. Where is that in the why that is true? Where does the plaintiff's expert say anything about why decelerated heart rate or cord compression means you must take the baby out and it's a departure not to? I didn't see any of that. Where is that explained?
He explains it. Can I give you the page references, Your Honor?
Yeah.
So it's going to be 277 to 278. And at the end of the affirmation, page 288.
And what does he say?
What he says is, he says that because this is a preterm labor, because there's preeclampsia, because the patient had uncontrolled diabetes, and because it's known that cerebral palsy, by the defendant's own literature, by the way, can cause cerebral palsy based on hypoxic events, that as soon as there's a problem with this particular mom, good and accepted standards requires no waiting. We're not talking 12 hours, we're not talking 9 hours, we're talking immediate. And we know from his review of the medical records, and Justice Scarpula, I'd ask you to look at 278 to 279, paragraphs 13 through 14, which contain a detailed discussion of that there are multiple decelerations going on for 12 hours, some as far as 9:15. There's a basic disagreement as to whether or not those decelerations were minor because they returned to baseline.
I agree there's a disagreement about the extent of them, but I don't see anything that explains your expert's conclusion that the fact that there is deceleration, I mean, there's deceleration lots of times where no C-section occurs. And there's cord compression lots of times where no C-section occurs. So I'm just still, again, I mean, what, and what about the, there's no discussion of, you would have seen white matter on the brain. The plaintiff's expert just really didn't address what the defendant's experts said caused this event post-birth.
So let me deal with both issues if I can, and my light is out, so I'm going to try to speak quickly. I'm going to try to speak clearly as well. What the experts said was, if you look at the actual nurses' notes and what the nurses actually did during the birthing process, and the terms they used, hyperstimulation, deoxygenation, they were dealing with a compromised baby in a compromised situation, which required removal of that fetus from the womb. With respect to the causation element, we pointed out that the defendant's own references to websites and to external articles actually supports our contention. The NIH article to which they refer lists in the disjunctive, not the conjunctive.
Let me interrupt you for a second and just ask you this one question. Sure. What did your experts say about the opinion that this baby's cerebral palsy was caused by bilateral strokes that occurred in utero? What did your experts say about that?
Our experts said that wasn't true, that it was caused
just
by
nothing, right? It wasn't true, but not why. Why did your expert say that wasn't true?
Because his review of the fetal heart tracings, his review of the nurse's notes, his review of the testimony of the midwives, which was not discussed at all in any of the defendant's submissions, showed that this baby was deprived of oxygen, and
at
deprivation,
birth, and there was nothing, had nothing to do with these strokes. Can you tell me where in your expert's report that was?
I gave you the...
Just those 2 pages is what you're saying, that's how he...
Yes, it's
those 2 pages are the rebuttal to the defendant's opinion that this baby suffered from bilateral strokes in utero caused by the mom's uncontrolled diabetes during gestation.
Yes, if you want the thing, it's 11.
I just want, yeah, just tell me, because I...
Yes, the answer is yes. 11 to 14, paragraphs 11 to 14 and paragraph 19. Okay. And that's 277 to 278 and 288.
Okay, thank you.
Thank you.
Here's the actual language from plaintiff's expert's affirmation about what he or she said about the strokes. Cerebral palsy and its sequelae are not caused by strokes, but are in fact caused, as in this case, as a result of the deprivation of oxygen and hypoxic insults suffered by the infant plaintiff during labor and delivery.
Is that it? Is that
That's it. It's completely conclusory. Just rejected out of hand that a stroke could possibly be the cause.
But I thought that your expert also questioned whether there had been any strokes, or when exactly the strokes had occurred, and whether or not, when the strokes had occurred, whether they occurred prior to labor or delivery. And I thought that the motion court had said that there was there were factual issues as to exactly what occurred with the strokes.
Our experts didn't, what our experts said was we can't say with absolute certainty sort of like what day it was, but they said in all likelihood about 2 weeks prior to delivery. They definitely said that it was prior to delivery. And what the motion court... Did
your experts not also take issue with whether or not the strokes actually occurred during the gestation, during the pregnancy?
They didn't take issue with it. That was their conclusion, that the strokes occurred in utero during pregnancy. And what the motion court was referencing was the plaintiffs came back and said, well, no, there's evidence that the strokes occurred. They found a doctor's note, I think from when the child was 9 or 10, that took a history and said that the strokes were neonatal. So they took that to mean.
What about your adversary's argument that it was a departure in and of itself based upon the plaintiff's medical history, that she should have had a C-section immediately just based upon her prior history and based upon the nurse's notes?
Yeah, I don't think, I think some of that is a little bit of gloss being put on it by the attorneys. I think the actual, I don't think the expert said necessarily because of her history. The expert did clearly though say at the first instance of fetal distress, but I think as Justice Scarpullo pointed out, there's nothing to back that up. And I mean, there are instances of decelerating heart rates, and that's fairly common, and there is nothing to sort of back that up. It's just a sort of a classic kind of like, I would have done it differently with the benefit of hindsight. And that shouldn't be enough to create a material issue of fact as a departure. But as I said before, I don't think the court necessarily needs to address departure because I think we're so strong on causation as the clear-cut ground for reversal here. And if your honors have no further questions.
Thank you. Perez versus New York City Civil Service Commission.
Good afternoon. May it please the court. Stephen Bergstein for the plaintiff appellant. The commission's adverse findings were arbitrary and capricious as to whether Perez had engaged in fraudulent acts. There are two civil service positions that are relevant to this appeal. Let me start with sanitation. There were two investigations. The first investigation cleared Perez of any fraud allegation. 3 years later, the commission, the DCAS, again investigates the circumstances surrounding plaintiff's departure from sanitation and now finds that he engaged in fraud. But the second investigation did not unearth any new facts relevant to...
Well, didn't the second investigation bring to light, it's me speaking, two letters where it then led, that indicated that he was facing disciplinary action and he resigned before that they could act on that? So that he was fully aware when he was asked afterwards, were you facing or did you leave under the cloud of any investigation? He said no.
Those two letters said the same thing as documents that were present during the initial investigation. If you look at these documents side by side, they're all saying the same thing. During the first investigation at page 1441, plaintiff signed his name on the probation report and said, I have seen and understand the review's recommendation to terminate my employment. So the new, quote unquote, new documents didn't say anything differently than what the investigator had already known about.
I thought that the initial investigation did not disclose whether the plaintiff was actually aware of the impending dismissal when he resigned. And it was not until the later receipt of those documents and those letters that it became clear that the plaintiff was aware of the pending dismissal, the impending dismissal when he resigned.
Not exactly, because in the first investigation, there were documents that showed that plaintiff was aware of his pending dismissal. That's page 1441 of the record where he actually signed the probation report, his acknowledgement, with the separate from service recommendations from the supervisor. So the new
was that based upon disciplinary issues or based upon his work performance, or was it based upon something else?
Yes, because it was a probation report that talked about his work performance. So there may have been technically new records in the second investigation, but they didn't say anything new that was not already before the investigator the first time.
Well, they knew that they were he knew that they were possibly contemplating charges, but he did not know that the charges were actually forthcoming until the second letter.
So he knew that his termination was imminent. That can only happen when you have disciplinary charges. So if you look at the records, and I can just repeat them for the record here, page 96 of the record and page 1441, those are the comparable documents that demonstrate that Bonner knew and was aware of the truth about plaintiff's departure.
And that's what led to his resignation, was because he then knew that the charges were forthcoming.
But they knew that during the first investigation too, and they still cleared him.
But they did not know that he knew this.
He signed the probation report In the first investigation, they knew this. He signed a probation report that said his termination was imminent, so he knew his termination was imminent.
So then why, when he was asked, when asked the question, have you ever resigned from a job to avoid termination or disciplinary action, did he answer in the negative?
That's an issue, but
Well,
Boehner,
that's a big issue, isn't
it's an
it?
issue, but my response to that is Bonner knew that and still cleared him, probably because of departmental policy that's in the record at page.
But the question is more about the petitioner here, and the fact that the petitioner is engaging in what appears to be fraud.
But the
That
agency,
he's saying he's lying about it. He's
But the
lying about
agency-
what he knew.
but the agency cleared him because there was apparently a flexibility. policy.
What if the agency clears him and then something, comes to light in a different way? They realize something in a different way, and ask the person who's working for them about it. Can they not rely on the person to tell the truth? And then the person lies about it. They have to just go on saying, oh, well, we knew about it originally, so the fact that he lies is irrelevant?
My response is, if they knew about his answer the first time and they knew the circumstances and they cleared him of fraud, they need a really good reason to change their mind the second time around without new evidence. There's a policy in the record that the city doesn't seem to dispute, a flexibility policy about the hiring and rehiring of candidates. It's page 1372 that probably explains why they cleared him the first time. Why did they then rule against him the second time without new evidence? That's arbitrary.
Well, see, counsel, you argue that in your papers, which I did not understand. Once they learned that there is a fraud or that a fraud had been committed, why would they not be within their rights to terminate him? You seem to argue that because they cleared him the first time, that, all hands were off and no further action could be taken against him, almost like an estoppel argument.
It is an estoppel argument. They knew the truth. They knew what happened the first time. They cleared him.
Based upon incomplete or insufficient evidence.
It wasn't insufficient. It wasn't insufficient.
But they made a determination that it was insufficient, so therefore why would that be arbitrary and capricious on their part if they made that determination?
It's arbitrary and capricious because it wasn't based on insufficient information from the first investigation. They learned nothing new. If they're going to change their mind, I think they need a really good reason for that.
So this decision, if we were to agree with you, you're basically saying that there's no way to go back and correct something if later on there is a misrepresentation.
Not after 3 years, because the first findings said there was no fraud, and they didn't learn anything new the second time.
And so where is it that states that that after a 3-year period of time, if you find that there's been a fraud or misrepresentation, a material misrepresentation, that there's nothing you can do to correct that?
Yes, because they cleared him and then changed their mind without any new information. 3 years, it's arbitrary.
So my question was, where is this written? Where does it state this policy or this rule?
Which rule? That I just articulated, or
yes, that you just articulated. That after 3 years, even if they find that there's been a material misrepresentation or fraud, that there's nothing they can do to correct their error.
Well, we're arguing there's no fraud. If there's no fraud, you can't do it 3 years later.
Thank you.
You can't wait 3 years.
You have some rebuttal, thanks.
Thank you.
May it please the Court, Claiborne Henry on behalf of the Civil Service Commission. This Court should affirm the dismissal of the Article 78 petition because the Commission had a rational basis to uphold the disqualification, the Perez's disqualification from employment.
Counsel, does the civil service law allow for the review of applications and applicants after they have been hired, specifically 50 subsection 4G?
Yes, Your Honor. What happened in this instance was Perez was a substandard employee and he was subject to a disciplinary investigation. And during the course of that disciplinary investigation, they stumbled upon this evidence that he had resigned in lieu of dismissal or...
So, I'm sorry, when you say they stumbled upon this investigation, counsel kept saying that there was nothing new. Was this new or not new?
Oh, it's absolutely new, Your Honor. So there are two agencies here. There's one of the concerns the Department of Sanitation. The other concerns the New York City Housing Authority. He worked at both of those organizations. With the New York City Housing Authority, he was discharged after a disciplinary hearing. He then sued and was permitted to resign in lieu of that dismissal under a settlement agreement. He was then asked on his job application, have you ever resigned to avoid dismissal or termination? And he answered no. Yet that is exactly what happened at the at the New York City Housing Authority. And the investigator at the Department of Citywide Administrative Services, which was the agency that employed him, testified they didn't have that information. They didn't have that settlement agreement. And so that was absolutely brand new information. So, counsel spent most of his time discussing the documents that they had with respect to the Department of Sanitation. And our position is that the two letters that they had regarding the Department of regarding his acknowledgement of the Department of Sanitation's probation report constituted sufficient new information as well. But even if we put that to the side, we can simply look at the circumstances surrounding his departure from NYCHA. And that in and of itself provides a rational basis to disqualify him. Again, he was discharged from NYCHA for disciplinary reasons. He sued pursuant to a settlement. They allowed him to resign in lieu of termination. He was then asked on his employment application.
But what about the fact that he argues that part of that settlement allowed him to answer such questions in the negative? Does that matter?
Not at all, Your Honor. If that settlement didn't allow him to deny that the deal had taken place. He didn't have to disclose on his application that he had been terminated. He didn't have to disclose the circumstances for why he had been terminated. He was simply asked on his application, have you ever resigned in lieu of termination? And he had an obligation to answer that question truthfully.
So, counsel, I'm a little confused. Chronologically, he was at NYCHA for 6 years. Is that correct?
Yes, Your
Around
Honor.
that. Then he leaves NYCHA and he goes to the Department of Sanitation.
Yes, Your Honor.
And he's at the Department of Sanitation less than a year, right?
I don't remember the exact
Okay,
time
and then he
period,
goes
but
to
yes.
DCAS.
Correct, Your Honor.
And so it's at DCAS now that they're doing the investigation?
Yes, sir. So when he joins DCAS, he's immediately a highly problematic employee, and they start a disciplinary investigation into all of these complaints from various supervisors. During the course of that investigation, they learn that he has worked at other city agencies and has also been a very problematic employee at other city agencies, and moreover, that he had been terminated from NYCHA, but was permitted to resign in lieu of termination, and that with respect to the Department of Sanitation, that he had been, that disciplinary charges had been imminent.
I want to get back to that because I think you sort of put it on the side. What about these two letters? Were they new or were they not new?
Oh, the new
Were they
letters.
new to, did they have them all along? What was that?
Oh, no, Your Honor, and I think there'll be absolutely no dispute about that. The letters were completely new, and these are two letters in which he wrote to the Department of Sanitation saying, I acknowledge receipt of this probation report, and I'd like some time to talk about it or to...
Were there any other documents that they had with regard to sanitation that showed that the petitioner was aware of the charges? Or was this the first time it was coming to their attention that he was aware?
No, Your Honor. During the first investigation, there was sort of conflicting evidence. They had these documents that suggested he may have been aware. However, the investigator also testified that during that first investigation, he had also learned that Perez had never received a charge package, and he spoke to Perez, and Perez said, I've never resigned from a job to avoid dismissal. And when he got these two letters at the subsequent investigation a few years later, he sort of learned beyond any doubt that Perez did in fact know that dismissal was imminent. But again, we can completely disregard what happened in the Department of Sanitation. I think what happened with respect to NYCHA is so clear-cut. He resigned in lieu of termination. He lied about it, and that provided a rational basis to disqualify him. This court should affirm. Thank you.
I know I only have a minute, so let me use my time wisely. In their brief, the city says in footnote 1, page 7, that DCAS knew during the first investigation that Perez signed a statement recommending his dismissal. That's how they deal with the similarity of both documents. As to NYCHA, the question is, did he lie when he said he didn't resign from NYCHA? He didn't lie. He was fired from NYCHA. So it's the truth. he didn't resign. The retroactive resignation pursuant to his settlement doesn't mean he didn't stipulate in settling the case that he resigned as a means to avoid discipline. So even if we consider the
He did
retroactive...
not resign from NYCHA? You're saying NYCHA terminated him? I thought he was allowed to resign.
No, NYCHA, he originally was fired. Then he brings a lawsuit, they settle, and then they say, okay, we'll classify your termination as a resignation.
Right.
But when he left, when he originally departed from NYCHA, it wasn't a resignation, so he wasn't lying when he denied resigning any position to avoid discipline. Complex, but
Thank
I think
you.
our reply brief really lays it out. Thank you.
Thank you both. People versus Alex Ocasio.
Good afternoon, Your Honors. Matthew Christiana on behalf of Alexis Ocasio. At age 40, and fueled by his struggles with drug addiction, Mr. Ocasio entered a few apartment buildings and stole items from unoccupied areas to obtain money to support his habit. He never entered anyone's apartment, he never encountered another person, and he quickly took responsibility and expressed a sincere remorse at sentencing.
Well, these burglaries were video surveillance, right? One was he allegedly went into the basement and these were video surveillance, which he admitted that he was the individual depicted on the video. One incident, he went into the basement and took a nail gun or two nail guns, and the other two incidents, he was taking packages from in front of the doors of tenants.
Yes, well, one of the package thefts was from the common area inside an apartment. The other one was just after, I believe, the postal carrier dropped them off outside the building.
Right, and so these were all on video surveillance, which he admitted that he was on the surveillance, right?
Yes, and he quickly took responsibility, I think, from arrest to sentence. We're talking about less than 2 months.
And it was 3.5 to 7, consec to 1.5 to 3. Was that the sentence?
Yes, Your Honor. Yes, Your Honor. For an aggregate total of 5 to 10 years. And 5 to 10 years in this case is excessive, especially considering the non-confrontational and nonviolent nature of the offenses. Modifying the two terms to run concurrently and reducing the third-degree burglary count for an aggregate total of 2 to 4 years is more than appropriate here. And I just would like to note as well that this is a case where the probation department below considered 3.5 to 7 to be an appropriate sentence considering all the factors. And in the probation report on page 2, they mistakenly believed that the sentences were to run concurrent and that the sentence would be 3.5 to 7. But nevertheless, they concurred with that opinion, knowing all of the facts of this case. But 3.5 to 7 in this case would also be excessive, and 2 to 4 is the appropriate punishment. Without minimizing the conduct, this was not an offense committed by a violent or a hardened criminal. It was an offense committed by a man who suffers from drug addiction in the midst of a relapse. Mr. Ocasio is capable of getting and staying sober, thereby eliminating the underlying force of this conduct. He has recognized that he needs help, and he has already taken steps immediately to get that help. Pending incarceration on the current offense, he enrolled in the Keep Methadone program, and then through plea and sentencing, he advocated for ASAP for the Elmira Methadone program.
Could you tell me again what the consecutive terms were?
I'm sorry, Your Honor?
Can you tell me again what the consecutive terms were?
Yes, Your Honor. On the attempted third-degree burglary, it was 1.5 to 3, and then on the third-degree burglary, it was 3.5 to 7. So the total was 5 to 10. As Mr. Ocasio's actions indicate, he is ready, willing, and determined to seize any and all treatment opportunities available to him. He truly wants to get better, but the treatment that he needs is largely unavailable in any effective form while he's in state prison. 2 to 4 years, he would provide him a significant punishment proportionate to the underlying offenses, while also allowing him an earlier opportunity to gain that help that he so desperately needs. And I also would like to note as well that, and we included in our brief, that our office has a reentry program staffed by social workers and attorneys to help assist him and provide him the tools that he needs to lead a successful post-incarceration life. So 2 to 4 years here, Your Honors, is appropriate. And I would like to just briefly touch on the waiver, or the purported waiver. There was no valid waiver of appeal here, and it's all on page 8 of the plea minutes. During the oral colloquy, the court erroneously classified the waiver as an absolute bar to the right to appeal.
So was he a predicate? That does sound like predicate sentences. Was he a predicate?
Yes, Your Honor. His predicate was from 2011. So that was 10 years ago. He was 33 at the time. And
What was that for?
It was
the
for
underlying felony conviction.
third-degree robbery, which, again, is consistent with this idea that Mr. Ocasio is a man suffering from addiction.
He was not offered a program at all?
I'm sorry?
He was not offered a program at all?
In this case?
Yes.
It's unclear. He had advocated for it through plea and at sentencing, and I believe it was indicated on his commit card. The court did that below, but it's unclear the extent of the treatment that he's getting, and if any at all, our prison systems are not effectively equipped to treat mental illness and substance abuse. And just briefly as well, yeah, the court in this case characterized the right to appeal as an absolute bar, or the waiver as an absolute bar, which is a fatal flaw that negates the validity of a waiver, notwithstanding any written waiver. So this case is properly before this court, and the equities in this case suggest that a term of 2 to 4 years would be appropriate. Thank you, Your Honors.
Thank you.
Good afternoon, and may it please the court. Faith Petrolio for the people. In this case, defendant validly waived his right to appeal and received a fair and appropriate sentence as a part of a negotiated plea. First, defendant's waiver of appeal was valid. The court engaged in a thorough colloquy to ensure that defendant's plea was knowing, voluntary, and intelligent, and carefully distinguished between the litany of trial rights defendant would be automatically forfeiting as a result of his plea and his separate waiver of his right to appeal. The oral colloquy was supplemented by a detailed written waiver of appeal, which defendant signed with counsel in open court. And
What about what counsel indicates about the court saying it was an absolute bar?
Your Honor, the court below said that the defendant's case would end with the plea and sentence, but as the Court of Appeals has found in People v. Thomas, that even statements such as that the defendant's case would end with the sentence could be, that doesn't necessarily mean the plea is invalid, given the fact that, especially in this case and in Thomas, that the defendant also signed a written waiver of appeal, which specifically told him the rights that he was waiving as part of his plea, but also—
Was that done on the record?
I'm sorry?
Was that done on the record, the signing?
Yes, the signing was done on the record. In the beginning of the proceeding, counsel was provided with the paperwork and then later told the court that she was ready to proceed after signing the documents with her client.
Was it reviewed? Oh, the counsel said that? Okay.
Yes. Further, in any case, defendant received a fair and appropriate sentence. He received the exact sentence for which he bargained and to which he consented. And moreover,
What the facts about what the defendant's arguing now or is presenting now that the drug addiction and those circumstances should be considered by this court as a way to reduce his sentence in the interest of justice. Were those facts known to the trial court when the sentence was made?
Yes, they were. They were in the pre-sentence report, and counsel brought them up to the court in the plea proceeding and in the sentencing proceeding. So they were well known to the court and is not a basis for extended leniency here. Further, the sentence was very lenient. The sentence covered both the burglaries he admitted to and was convicted of in this case, and any uncharged second-degree burglary cases for the preceding 2 years. And additionally, as the court noted, he is a predicate felon for a 2011 third-degree robbery, and the convictions in this case were his 5th and 6th felony convictions. He also has 10 misdemeanors. So given his potential exposure in this case, he benefited greatly from his plea bargain. And so if there are no further questions, we ask that you affirm.
Thank you.
Thank you.
So just briefly to start with the purported waiver in this case. First, there was an absolute bar, as was conceded, or at least supposed absolute bar, and that's on page 8. The court said you give up your right to file these appeals, and it's going to end with the plea and sentence. And under People versus Bisono, a mischaracterization of this magnitude is a fatal flaw, notwithstanding the contents of a written waiver. So this claim is properly before this court. And there was an appellate waiver that was signed, but it's unclear when it was signed. I mean, there was a few waivers that were signed in the beginning. There was no discussion surrounding what was being signed at what time. So there's
It's rare that there is more than one waiver. Why were there multiple?
because there was also the waiver by, these were under informations, so there was the waiver for prosecution by indictment.
This was an SCI?
Yes.
So you're talking about the waiver of indictment?
Yes, yeah, there was a few waivers that were presented, and there was
Different waivers.
Yes, and I believe there was 2 for each case here, so 4 waivers. But if I just may say one last thing about my client's sentence, the court, my client's drug addiction wasn't the pre-sentence report, but all of this was within a 2-month span. And that doesn't negate the fact that a 2 to 4 year sentence here so that he can get the help that he needs and eliminate the underlying driving force of his conduct is necessary. So thank you, Your Honors.
Thank you. Thank you both. Castle Point versus Mount Holly.
Good afternoon, Your Honors. Max Gershwire for Plaintiff Castle Point Insurance Company. Castle Point simply asked the court to construe an insurance policy exclusion exactly as it was drafted, and in the same way that the drafter, defendant Mount Holly, applied it in connection with 4 prior claims. It does not contest our indistinguishable.
Let me see if I got this. For me, it looks like Castle Point stepped in the shoes of Vordonia, who's a policyholder under Mount Holly's policy, right? So you stepped into their shoes so that then you turn around and it's almost as if a policyholder sues the insurer and the DJ action saying, you got to cover me. So that's what you're doing, right? I mean, essentially, you stepped into the policyholder's shoes to go after Mount Holly, saying that you breached the contract, you're supposed to cover Vornado, correct? I mean, that's what you're looking to get, right? Because they didn't, it's all about the indemnification that's going on here, correct?
Yes, Your Honor. Yes, Castle Point.
I mean, there was just so many carriers going on here. You're just simply taking over the policyholder's lawsuit against the insurance company.
Right. So that's correct, Your Honor. That is the procedural.
And then their argument, their defense is that there's this cross liability exclusion. You can't, a named insured cannot sue another named insured, right?
That's right.
But in this case here, you're not really a named insured, right? I mean, you're more of a
that's precisely right. Mount Holly disclaimed coverage to its own insured, Vordonia, in a case that was brought by Castle Point. Right? So they're saying, even though they drafted the exclusion to say we won't cover a claim brought by a named insured, they could have said we won't cover a claim brought by a named insured or its subrogate or an assignee or any party acting under the rights of a named insured. That's not how they drafted it. They drafted it explicitly to say only named insured against named insured. The underlying case here was not brought by a named insured. It was brought by Castle Point. Castle Point is not a named insured under the Mount Holly policy. So that's,
well, the additional insured was not Castle Point. I mean, you stepped into the shoes of the additional.
That's right. They're not.
Trumbull was the additional insured.
Trumbull was an additional insured. Right. The way that Mount Holly is trying to shoehorn this exclusion in is to say, well, but Castle Point was acting on behalf of Trumbull. Trumbull is named insured under our policy, but
that
apart from the fact that
that policy wasn't at issue though. That policy where Trumbull was a named insured is not the policy that's being listed.
The premises. So it's an unusual policy in the sense that
you telling me.
Yeah, in the sense that Trumbull is identified on the policy as both a named insured and an additional insured. When you look more carefully, you see that they're named insured for a completely unrelated property.
Right.
For the property at issue here, they are named exclusively as an additional insured. So even if you were to say the exclusion applies to subrogates of a named insured, even though it doesn't say so, Here, under these circumstances, Castle Point was not acting as a subrogate of named insured Trumbull. It was acting as subrogate of additional insured Trumbull, because that is the property at question that was tied to their status as named insured, as an additional insured. The other thing, of course, is that Mount Holly had 4 prior claims arising out of the same incident, where because there was a claim by or on behalf of Trumbull against Vordonia, they could have said, this is how we read this exclusion, so we are going to disclaim on those claims as well. They didn't do it.
They didn't.
They never even suggested on those 4 prior claims, which they don't even contest are indistinguishable from the one here in terms of the applicability of exclusion. No, they never mentioned it. Not only did they defend Vordonia in those cases, but they actually paid a claim, a subrogation claim, brought by Trumbull's subrogee in a separate action arising from the same incident, without ever mentioning the exclusion. All of a sudden, for the 5th time, they're now saying,
I think this case hit all the terms: assignee, assignor, subrogee, subrogor, insurer. I mean, you got everybody.
Yeah, there's
all the labels that you could think of.
Right. Yeah. So there's really, there are the three bases for reversal. Three separate ones. The way the exclusion was drafted doesn't include subrogees. The fact that Trumbull in this case was an additional insured, not named insured in connection with the subject property. And third, because on those 4 prior claims, Mount Holly, indistinguishable, doesn't contest they weren't, never mentioned the exclusion and didn't rely on it to disclaim on in those occasions.
Thank you.
May it please the court, Timothy Delahunt for Mount Holly Insurance Company.
Strip it down to the bare essential. This is basic. You're going to win or lose on the cross liability exclusion, right? Insured cannot sue another insured.
Yeah, Your Honor, I think that's the only bona fide issue before the court, as I mentioned in my brief, and I'll explain very briefly why. The waiver argument just has no legal home.
No, forget the waiver. I mean, let's just stick right to the point. The cross liability exclusion. Named insured cannot sue named insured. Why is the cross Castle Point stepping in the shoe of Trumbull named insured now?
They're not a named insured.
They're not a named insured.
Correct.
So how do you get this exclusion then?
Because Castle Point their argument is not just unreasonable, it's based on a legal impossibility, which is that a subrogee has more rights than its subrogate.
I don't need to look at impossibility. I'm just looking at your terms of your exclusion. It says named insured can't sue a named insured, unless I'm totally not reading this right. And if you cannot demonstrate that Castle Point stepping in the shoes of Trumbull is a named insured, then this cross liability exclusion doesn't apply. And you just said that they're not a named insured.
The exclusion.
Unless I heard you wrong.
No, the exclusion makes sense and applies to a claim.
Yeah.
Right. The claim here was Trumbull's claim against Vordonia.
Yeah.
Castle Point, along the way, acquired the rights to it.
So when Trumbull sued Vordonia, is that a named insured suing a named insured?
Yes.
You just said that Trumbull was not a named insured.
No, I said Castle Point was not a named insured because they're not.
How is Trumbull a named insured in that?
Trumbull's a named insured and an additional insured under the policy. It depends on what claim is being brought against Trumbull.
As a named insured, we've already discussed with opposing counsel, of course, that the different property is listed in that particular.
Yes.
So they wouldn't be a primary insured in that.
Your Honor, there's a distinction, fundamental distinction between Trumbull as an insured. Trumbull being sued, it needs coverage. It has some coverage under the policy as a named insured. It has other coverage as an additional insured. This is not about Trumbull seeking insurance coverage. Trumbull's the plaintiff here. It's Trumbull's liability claim. It's Vordonia's coverage that's at issue here. So I said in my brief in a couple places, it's a non sequitur, I believe it is, to make arguments premised on Trumbull's status as an insured. Trumbull's the plaintiff here.
I think for me, you're overcomplicating it. You got Vordonia's insurance policy That's you guys. Mount Holly insures or provides a policy to Vordonia, correct?
And Trumbull, yes.
Right?
Yes.
So that what happens here is now Trumbull sues Vordonia, right, for whatever claims they're doing, right? And then Trumbull decides to then somehow work out an assignment with Castle Point. So the Castle Point now switches, they step in the shoes of Trumbull. That's not what happened?
No, no. Castle Point subrogated to Trumbull's rights. Castle Point's assignment was with Vordonia. And Your Honor, your very first question to counsel was, in essence, isn't this a direct action by Vordonia? When you reduce it down, it's a direct action by Vordonia against Mount Holly. And it is. That's exactly right.
Yeah.
And as against Vordonia, the cross-liability exclusion applies because the claim for which Vordonia is seeking coverage, really Castle Point, was Trumbull's claim against Vordonia. Both
Only if, in that scenario that you just stated, that you have two named insurers on both sides of the equation.
Well, you did, Your Honor. You had Castle Point, ASO, Trumbull. That's the key.
Yes.
Only Trumbull's rights are at issue. Castle Point has no rights.
Right, so in that scenario, you're saying that Trumbull is a named insured?
No. What I'm saying is Trumbull's a named insured under this policy. Trumbull was suing as a plaintiff against Vordonia. It was Vordonia that needed coverage.
Yeah, I got
The
that.
policy says, Vordonia, you don't have coverage when your own landlord, which your common ownership, is suing you, another named insured.
I'm more interested in Trumbull. Vordonia is not the problem here. Trumbull is the issue, right? I'm more interested in Trumbull, right? So is in your position is Trumbull is a named it's either a named insured or additional insured, and according to the appellate, it's both.
There's a third option? You were shaking your head. I thought that the only two options were a named insured or an also insured.
Trumbull's both. Indisputably, they're both under the policy. Why the exclusion applies has nothing to do with Trumbull's status as an insured, be it named insured or additional insured. Trumbull's the plaintiff. It's Vordonia's coverage. Vordonia was the entity being sued. Does Vordonia have
Wait, you are saying that the exclusion protects you?
Mount Holly.
Right, exactly.
Correct, yes.
Right.
That's what
So,
exclusions
but
are
the
for.
exclusion is for an insured against an insured. So who are the two insureds that you're saying step into those positions so that the exclusion applies?
Trumbull's a named insured and an additional insured under the policy. Vordonia is a named insured.
Okay, so then the questions are directed to not the issue with Vordonia, but with Trumbull. How is Trumbull a named insured, not as an additional, but as a named insured?
Because the policy lists Trumbull as a named insured.
Where? That's the thing. It lists Trumbull with respect to different properties, not this property. So how does that make them a named insured here?
Trumbull's not, for purposes of this claim, Trumbull is not seeking coverage. It's the plaintiff. But the exclusion applies because these are common entities suing each other. These exclusions are very common. They're very simple. Are you both named insured under policy? We don't cover internecine claims, okay? But Trumbull is not seeking coverage here. Only Vordonia is.
Thank you.
Thank you.
You want to clean that up a little
You
bit?
have your finger on the pulse here. The problem is that with regard to the property at issue, Trumbull is an additional insured, not a named
Yeah,
insured.
he kept saying, though, the argument I keep hearing is it's not Trumbull, it's Castle Point. Castle Point,
Well, those are two separate arguments. One argument is it doesn't matter if Trumbull was a named insured or an additional insured with respect to the property, because the claim that was disclaimed was a claim brought by Castle Point.
Right.
As Trumbull's subrogate, but again,
Yeah, but that's
you
not,
go by the
but
policy
like you
language.
just said, it's as subrogate of Trumbull. I mean, it's in place of Trumbull that Castle Point
Right,
brought the
that's
lawsuit.
true, but again, if Mount Holly had wanted to exclude claims by named insureds or their subrogees, it should have said so in the exclusion. But even putting that aside, so it's a two-pronged argument. Even putting that aside, in the context of this claim, Trumbull was an additional insured, not a named insured, because the property issue is only tied to Trumbull as an additional insured.
Thank you.
Thanks, sir.
Thank you both. Cedon versus SUNY Downstate Medical. Cedon, yep.
Good afternoon, Your Honors. Rania Sedholm for Layla Sedholm. New York, as a matter of fundamental policy, seeks to eliminate the profound evil of discrimination. For that reason, the burden is de minimis to establish an inference of discrimination in favor of plaintiffs such as Dr. Sedholm. And both the New York State and New York City human rights laws must be construed broadly in her favor to the extent reasonably possible. Due to our limited time, I wanted to highlight 3 instances of discrimination for you. First, the lower court did not address the fact that excluding Dr. Sedholm from meetings is a stark indication of discrimination. The court below noted that Dr. Sedholm could not recall specific meeting dates, but again, people don't remember minute details and dates. Second, SUNY stated that its policy in 2017 was to convert all temporary employees to term employees. However, what it did in February 2017 was convert 15 of the temporary employees to term employees. It did not convert Dr. Sedholm, and she was the oldest person on that list. Third, Daisy Cruz Richmond states that she wanted to give a free hand to the new dean to shape her administration. In that regard, why then did she only terminate 1 person in the administration? 3 others remained. Also, Daisy Cruz Richmond believed that Dr. Sedholm was tenured. That is why she simply didn't terminate her in January 2017 and instead repeatedly threatened to terminate her and did so 6 months later in July 2017. And whether or not she believed she had tenure goes to her intent, which goes to her discriminatory conduct. When Daisy Cruz Richmond threatened to fire Dr. Sedholm, she stated to her that I am terminating you, I'm going to terminate you, and I'm going to post your position, and you will be ineligible to apply for it. By forbidding Dr. Sedholm from applying for the position, Daisy Cruz Richmond foreclosed 1 option to the new dean. That is not the same as giving her a free hand. The cases relied upon by SUNY are distinguishable. 12 of the 20 cases to which they cite relate to a claimant that has performance issues. The record is clear. Dr. Sedholm, as Daisy Cruz Richmond testified herself, is dedicated and hardworking. As such, those cases are distinguishable. In Godbolt, the plaintiff falsified his job application. In this case, there is no allegation that Dr. Sedholm was dishonest. The SUNY defendants failed to cite to any single case where there was a claimant like Dr. Sedholm, one who had proper qualifications for the job, one who had no performance issues, and one who was summarily dismissed and treated differently than everyone else. Under the New York City human rights law, that is all that is necessary for her to prove, and it is probative under the state human rights law. Thank you.
May it please the court, my name is Stephen Yanni, and I represent the SUNY defendants. The court should affirm because plaintiff has failed to establish even a prima facie case of age discrimination. There's no evidence that the decision maker in this case, Dr. Cruz Richmond, who herself was 71 years old at the time, decided to fire plaintiff due to her age or ever referenced her age at all. To the contrary, Dr. Cruz Richmond, in addition to being a member of the protected class herself, was the individual who rehired plaintiff after her retirement. And after plaintiff was terminated, her duties were transferred to an even older individual. The record therefore makes clear that discrimination did not motivate plaintiff's termination. And I'd like to note that several of the instances that plaintiff points to as evidence of discrimination are plainly outside of the record, including the allegation made here that of all of the temporary employees, plaintiff was the oldest one and the only one terminated. That's just nowhere to be found in the record. And the same is true of one of the main stray remarks upon which plaintiff relies to support an inference of discrimination in this case, namely that Ms. Silas, a human resources manager, told plaintiff that she was, quote, too old. But the record just demonstrates that that was never said, and plaintiff admitted at page 882 that she never said that. And in any event, plaintiff does not allege that Ms. Silas, or the record does not support that Ms. Silas had any authority to terminate plaintiff, so this comment is even of less probative value. And the same is true of the additional stray statement attributed to Ms. Dorsey, who allegedly stated that plaintiff had been at SUNY, quote, a long time. This is another individual who had no decision-making authority, and this is just simply another stray remark that's not actionable under the case law. And the other incidents to which plaintiff refers are just personality conflicts or petty slights, and those are not actionable as a hostile work environment, and they don't support an inference of discrimination in this case. Plaintiff focused in her argument on the exclusion from meetings, but when asked about the incidents of discrimination in her deposition, plaintiff could only remember a few discrete instances, and at page 888 of the record, she clarified that those were the only ones that she could remember, and exclusion from meetings was not part of that. In any event, I think it's also important for the court to consider that there's nothing tying each of these events to plaintiff's age, which is key here. Nothing in the record suggests that any of these conflicts that plaintiff allegedly had with Dr. Cruz Richmond or others were attributable to her age. And in any event, the defendants also showed that plaintiff was terminated for legitimate reasons here, namely that, one, the university wanted to reduce its reliance on temporary faculty appointments.
What about what counsel said, that they said they wanted to change from temporary to term, but only did so with 15 employees, not all of the employees?
Well, Your Honor, that fact is outside of the record. I don't know to what portion of the record counsel is referring. It is correct that plaintiff's temporary status was, her temporary employment was not renewed afterwards, but there's nothing in the record to suggest that she was the only one that was not converted to a term appointment. In fact, and there's also no evidence in the record that these explanations were pretextual. Dr. Cruz Richmond testified in her affidavit that 15 of the 17 associate deans and directors she had during her tenure were over the age of 60 when appointed. And taking that fact along with the others that I mentioned, it's clear here that plaintiff can't establish that she was terminated because of her age. And if the court has no further questions, I'd ask you to affirm. Thank you.
Thank you.
Thank you, Your Honors. I wanted to clarify a couple of points. The law is clear under both Wiggins v. Mount Sinai 2020 New York Slip Opinion 34254 and under Priori versus New York Yankees, that as long as somebody has decision-making authority, they can be culpable under the statute. They do not have to be a decision maker with respect to the specific matter at hand. As such, it's irrelevant to whether Silas was a decision maker in terms of firing Dr. Sedholm. She testified that she supervised 7 people and that she has authority over compensation and the accuracy of all HR documents. She is clearly within statutory culpability. That's number one. Number two, Nellie Bailey, as the other counsel said, was transferred Dr. Sedholm's duties. She was simply a placeholder. It was only a few months. The person who actually took over Dr. Sedholm's position was much younger, approximately 42 years of age.
But wasn't she given a different position? Wasn't there a creation of a new position that was more technical? I think that was dealing with technology or something like that, that was different than what Dr. Sedholm was doing?
The title was certainly different, Your Honor, but there is nothing to suggest that Dr. Sedholm did not have the appropriate qualifications for the job. And Dr. Sedholm's responsibilities did not vanish into thin air. Somebody much younger is doing what Dr. Sedholm did.
Thank you.
Thank you.
Thank you both. People versus Van Din.
Good afternoon, Your Honors. Hillary Dowling on behalf of Ms. Din. We are asking the court to reduce Ms. Din's sentence to the statutory minimum of 2 to 4 years. Her current sentence of 3 to 6 years is excessive given the nonviolent nature of Ms. Din's conduct, which involved her attempts to shoplift from retail stores that had previously issued her trespass notices.
Is Ms. Din, I'm sorry, is she on parole now?
She is. She was granted merit release December 1st of 2020.
So what are you asking for in relation to that now?
The reduction in her sentence from 3 to 6 to 2 to 4 years would essentially reduce her parole term, which is currently set to expire in March of 2024. This would effectively reduce her parole term to expire in March of 2022. Additionally, her sentence is excessive given the extensive hardships that Ms. Din experienced during her upbringing and throughout her adult life, as outlined extensively in her briefs. The confluence of all these circumstances contributed to chronic homelessness, lifelong drug addiction, and mental health issues stemming from years of unaddressed trauma. And finally, and perhaps most importantly, her prospects for rehabilitation and successful reentry have never been so pronounced, given the impact of her advocacy efforts while incarcerated on behalf of herself and other incarcerated trans women. With respect to that point, I will just note that in terms of her prospects for rehabilitation, I want to highlight how this case is different from others in her criminal history. For her entire criminal history dating back to the early 1980s, Ms. Din identified as a transgender female and presented with traditionally feminine appearances, and yet every time she was incarcerated, up until this case, she was housed in all-male facilities where she was subject to physical and sexual violence and other forms of abuse. Therefore, prior to this case, any potential rehabilitated benefits of sentencing were completely eviscerated as soon as she walked into those male facilities. She was denied dignity, safety, and resources during all periods of her previous incarceration. Due to her advocacy efforts in this case and on behalf of other incarcerated trans women, she not only produced substantial changes and material benefits to the conditions of her own confinement, but was a catalyst to systemic change in the housing of transgender and gender nonconforming individuals in city and state custody.
I know parole can be onerous in terms of the supervision and the fears of violating parole, but in her case, does she not need that supervision? I mean, if she did not have that parole supervision or the assistance in terms of her substance abuse issues and her other, I think there were diagnosed mental health issues, does she not need that, and also help with her residence, et cetera?
Of course, parole supervision can assist with reentry and rehabilitation efforts. However, Ms. Miston has already been on parole for just over a year at this point in time, and many of the efforts that she's made since her release regarding housing, substance abuse treatment, programming for job training, she's actually taken on voluntarily of her own volition. Parole has monitored her. If the court is interested to know what she is doing now, I can expand on that. But parole has.
I just noted that when she was in the substance abuse program, it was a 24-month substance abuse program, and then she violated it.
Yes.
She violated after a year.
Yes.
So I'm just kind of concerned or wondering whether or not that continued assistance is not necessary. I also noted that there were a couple of programs, the Sylvia Law program and a couple of other programs, which were assisting her. And so I was wondering whether, again, she seemed to thrive with the assistance of those programs and therefore with the supervision.
And to add to that, isn't there a new law with respect to parole? I mean, in terms of it's no longer punitive. I mean, there's no longer technical violations get you in trouble. That's a recent enactment, correct?
Yes.
How's that? I mean, that's all workable, as my colleague's saying, to really get her, to stay within the rails.
I can address both of those as quickly as possible in turn. First of all, with respect to her relapse during the program that she was in during the pendency of the cases, she did relapse after 8 months. I would note that's noted in the plea transcript of the sentencing proceedings that there was no mental health component to that program, which her advocate believed was an issue because she hadn't received any mental health treatment addressing past trauma to coincide with her substance abuse treatment. That's since been fixed, as she has been working since her release on parole, started with inpatient, now in outpatient drug abuse, substance abuse treatment, as well as receiving mental health services through Bridge Back to Life. She's also doing job training through Housing Works and is entering a new training program to actually start working for Housing Works as an advocate and counselor for at-risk transgender youth in New York City, which was her goal when she was incarcerated. With respect to the new law coming into effect, the Less is More Act, I think you're referring to, there are retroactive, if I may, I know I'm a little over, but I'll just answer that question quickly. There are sort of retroactive calculations based on good time, essentially 30 days of successful parole, you get docked 30 days of your sentence. Based on my understanding of the law, if it were to have immediate impact when it came into effect, which I believe is in March of next year, then it would reduce her overall sentence by approximately a year, maybe a year and a half. However, I think that it is speculative to think that I don't know how long it's going to take for these sort of administrative calculations to be done. I think it's speculative and perhaps a bit ambitious to think that as soon as the law comes into effect, all current parolees are going to have their time recalculated. I know that it's something we're working on looking into, but it's unclear administratively how that would proceed, which could result in Ms. Dinh remaining on parole beyond the year and a few months that she will still be on parole, regardless of that law. And I believe that that's why this court should exercise its independent review power and reduce Ms. Dinh's sentence, because doing so would allow her to focus on the most effective means to continue her successful reentry.
And just one more question. How involved has parole been in the programs or in obtaining the programs?
My understanding is that they call her counselor at Bridge Back to Life every few months.
Did they get her the programs? I mean, were they instrumental in
She
getting these
entered the program through the help of the other agencies that she met during the pendency of her cases, including Prisoners' Rights Project at the Legal Aid Society, as well as the Sylvia Rivera Law Project. When she entered the program, parole basically just touches in with them to make sure all of her toxicologies are negative and how she's doing, which they have been, and she's been doing very well.
Thank you.
Thank you.
Good afternoon, Jillian Lewis on behalf of the people. Defendant here was given an incredibly lenient sentence of judicial diversion for entering a department store and stealing $1,800 worth of clothing. Defendant was able to avoid an incarceratory term until she squandered that opportunity by committing another felony. Defendant's extensive criminal history of 5 prior felonies, convictions, and 33 misdemeanors, and as defense counsel noted in the reply brief on page 9, note that defendant does extremely well under supervision. While incarcerated, defendant did well, and it is our position that the additional parole that she is now under will help her continue to thrive.
And and under the new law, technical violations in the past are no longer going to get the person in trouble, right? I mean, under the new law, there's a little bit more flexibility, correct?
Yes, Your Honor.
When's that going to happen?
I'm sorry?
When will that happen?
When will the new law go into effect?
Well, I know when that will go into effect, but when will the adjustments for people take place?
Your Honor, I'm not sure that that has been clear yet. However, the continued term of her having that supervision on parole, having that incentive, has been shown to be helpful in the past and can continue to be helpful. So if Your Honors have no further questions, we ask that you affirm the conviction below. Thank you.
Thank you.
Very briefly, I will just address the fact that with respect to Your Honor's question about technical violations under the new law, there is going to be more leniency with respect to those technical violations. However, they still can result in brief periods of incarceration. There's been changes in terms of whether someone has to be remanded upon a parole violation, but periods of incarceration can still be served for that.
But it's a move in the right direction. It's less punitive, because my understanding in the old law was very punitive. Now it's being a little bit more holistic in terms of where we're going with this.
Agreed, and I think it is moving in the right direction. And I will just also note to the prosecution's point that I understand the incentives of parole and that it can serve a rehabilitative purpose. However, the incentives that are drawn from this case are drawn from Ms. Din's experience and the steps that she's taken herself and the community that she has engaged with and the support network that has been created by that. I'll note that she's been on parole in the past and it hasn't always been successful, but at this point in time, the presence of all of those other resources and her own dignity is what's going to set her on the path for success.
Thank you.
Thank you.
Thank you both. People versus Brian Winston.
Good afternoon, Your Honors. May it please the Court, Lena Janota on behalf of Appellant Brian Winston. We're asking the Court today to find that the lower court improperly amended the indictment instead of dismissing the 2 defective counts. Now here, amending the indictment violated CPL 200.70 subsection 2B. To begin, it's uncontested here that the factual allegations of the original 2 counts of the indictment were legally insufficient. And this is something the respondent concedes in their brief, specifically on page 44 of their brief, something the court below acknowledged and that the people...
I want to direct your attention to CPL 200.70. In that first section, it says that the amendment, if the amendment doesn't change the theory or theories of the prosecution, then the amendment is okay.
No, Your Honor.
Why doesn't that apply, or does that apply here?
I would argue, Your Honor, that the language in the CPL, specifically that subsection, it first lays out that an amendment may not be made if it changes the theory of prosecution. An amendment may not be made if it prejudices the defendant. And then it goes, nor may an amendment be made for purposes of curing, and then it lists 4 separate defects. One of those defects is the legal insufficiency of the factual allegations. Now, that prohibition is separate and distinct from any kind of consideration of prejudice.
You're talking about section 2.
Subsection 2, yes. And then subsection 2 then goes and, as I said, lists 4 specific defects which an amendment
So essentially, you're saying that section 2 says even if it does change the theory of liability, if it does any of the things listed in section 2, you still can't do it.
Yes, Your Honor, and I can point to 2 cases that were before this court where that's been affirmed. In People versus Fernandez, this court held that amending an indictment is proper under this section of the CPL only where, quote, pre-amendment counts were legally sufficient. Again, here the factual allegations were legally insufficient, so the amendment was improper.
So which one of the sections under section 2 do you feel applies to this case?
The subsection 2B, Your Honor, the factual allegations were legally insufficient. The people attempted to charge Mr. Winston with assault 2 and attempted assault 2. They omitted a material element, again, something everybody has conceded. And by omitting that, the counts were legally insufficient. And so these facts are by no means new. In People versus Toodles, this court held that where an indictment omits a material element, the proper remedy is dismissal of those counts, not amendment. Now, the facts in Toodles are almost identical to those here. In Toodles, the indictment charged burglary 2. It omitted a material element, and by omitting that material element, it essentially charged the lesser included of criminal trespass.
What about section 2A? Does that apply?
No, our argument is that subsection 2B is, the language is very clear. It's clearly what's happened here. The people, again, the respondent conceded in their brief that these 2 counts were legally insufficient. The factual allegations were legally insufficient.
Are you reading the 2 subsections as mutually exclusive?
Yes, Your Honor. Based on the language, discussing prejudice and change in prosecutorial theory, and then it says, nor may an indictment be amended for the purposes of curing A, B, C, D. And B states the legal insufficiency of the factual allegations. And again, I want to draw the court's attention to People versus Toodles and People versus Aaron, which had nearly identical facts to this case here, in that the factual allegations were legally insufficient. Contrary to the respondent's assertions, we are in no way challenging a court's ability to charge a lesser included, but only when the original indictment was not defective. And the respondent cites no case law to support that a defective indictment can be so amended. Here, because those 2 counts were defective, an amendment was improper. As held by this court, dismissal is the proper remedy. And so for those reasons...
Turn this on. How do you distinguish the cases that state that you can amend an indictment to cure when there's a misnomer of the designation of the crime, where the factual allegations, there's no doubt here, right, that the factual allegations made out the lesser included. So how is that different from changing like a misnomer of the crime to a lesser included of the crime?
Yeah, Your Honor, if I may just briefly answer your question. If we look to People versus Rodriguez, that's a clear example of a case where there was a misnomer. It was a matter of form. A permissible amendment was made in that case, but that's clearly distinguishable.
Why? It's the same thing. It's a different crime. The underlying facts make out a crime. It's a different crime. You're saying because this is a higher or
If I may, Your Honor, the distinction that matters here, what's determinative, is not the location of the amendment, but the location of the error. In that case, in Rodriguez, the factual allegations alleged exactly what was intended to be charged, burglary 2, as a sexually motivated felony. The preamble mistakenly only listed sexually motivated felonies.
What about People versus Randall?
Pardon me?
People versus Randall?
People versus Randall doesn't provide any binding guidance, Your Honor. That case was actually a 1961 case, I believe. The CPL, specifically this section of the CPL, was enacted in 1973. And there's also.
But it says it's not intended, right, to displace the previous law. So you're saying it's.
Well, Your Honor, there's also no indication that the decision in Randall is very long. There's no indication that that case implicated a defective indictment, unlike here, and unlike this court has seen in Fernandez and in Aaron. And so because these two counts were clearly defective, the factual allegations were facially insufficient, the respondent has conceded that, amending it under the clear language of the CPL and under these two cases that have been before this court was improper. And so we just ask that this court dismiss those two Mr. Winston's two convictions which resulted from those two defective counts, the attempted assault 3 and the assault 3.
Thank you.
Thank you.
Good afternoon, Your Honors. Franklin Gunther on behalf of the people. This court held in People v. Miller and reiterated in People v. Rodriguez that a misnomer in the designation of the crime charged does not render an indictment jurisdictionally defective, because the jurisdictional sufficiency of the indictment is determined by reference to its underlining factual allegations. Here, the court's correction.
Counsel, you already indicated that, I think, perhaps I'm wrong, that this is jurisdictionally defective. It's a defective indictment, right?
The two counts in question were defective pertaining to the original charges in the indictment.
So what case do you have where there's a defective indictment and you can add a lesser included to the defective indictment, where the defective indictment are the greater counts?
I think this case is completely consistent with People v. Miller and People v. Rodriguez for the reasons that Your Honor stated before. In People v. Miller, all of the counts in the indictment were dismissed at the close of evidence, and the court concluded that it would nevertheless be proper to submit lesser included offenses because the factual allegations still made out those lesser included offenses, which were never separately charged. In People v. Rodriguez, the factual allegations made out a felony as a sexually motivated felony, but misstated the crime in the accusatory portion. And the court concluded, this court agreed, and the trial court concluded below that because the factual allegations still made out the crime, it was proper to submit those two charges. So there's no meaningful distinction between those two cases and what happened in this case.
So in this case, the factual allegations don't make out a second degree here.
That's correct.
Correct?
And those were never submitted to the jury.
Exactly. The second degree was submitted to the jury, but what is stated factually is third degree, not second degree.
Just to be clear, the second degree charges were never submitted to the jury. There was a lengthy.
I'm sorry, not the jury, the grand jury. The grand jury.
Grand jury, correct. Yes, those were properly voted out of the grand jury. That's correct.
That's right. And the indictment refers to the facts. The facts in the indictment are third degree, not second degree. And what you want to do here, what the lower court did here, was change the name, change the title, the actual title, not in the preamble, not somewhere else, the actual title of the indicted charge from second degree to third degree.
That's correct, Your Honor.
What's the...
I don't see that there's another case that's really comparable to that, because you don't have a greater charge here.
I understand that there's no case from this court that is directly on point with the facts of this one, but that doesn't mean that this case is not completely consistent with Rodriguez and Miller, which, again, Miller is explicitly clear that it is the acts charged which constitute the crime. It is not the accusatory portion. And to the point on People v. Fernandez, the distinction in that case is that the court amended the factual portion, or excuse me, the factual allegations, not the accusatory portion. In this case, the trial court, I think, recognized that this court has allowed the amendment of accusatory portions in those two cases that I just cited.
Maybe I'm asking a very simple question, but how's this doing what they did here in this case was basically changing the label, right? Is there a deprivation to the defendant's rights? I mean, it's prejudicing by doing that?
There's absolutely no prejudice to the defendant.
Why not?
Because the defendant is always on notice that he may be charged with a lesser included crime. If the factual allegations make out a lesser included, which they did here, there's no prejudice to the defendant that...
It's not like it's being upgraded, it's...
That's correct, and I think that's what the trial court recognized. The trial court had a lengthy colloquy with both sides throughout trial, and even up to the point of sentencing, where it was questioning whether it could amend the indictment by including the missing, omitted element back into the indictment, and determined that it couldn't do that, in large part because of 200.70 sub 2 sub b, which is what my adversary says is what happened here. But that is what happened in Fernandez. The court held that, although it was proper, that section applies when the court determines there is something missing from the factual allegations here. Can we change this or correct it some way so that it conforms to the accusatory portion? But there's no prejudice to the defendant in this case because he was always on notice that he could be charged with a lesser included offense, and it didn't change the theory of the prosecution in any way.
Why isn't this Section 2? Why doesn't Section 2B apply here?
Because there was there's no curing of the factual allegations because those charges were
But on its face, it's legally insufficient.
Pertaining to the charges which were never actually presented to the jury. If those charges were presented to the jury and there was some attempt to...
But what this says is an indictment may not be amended in any respect which changes the theory or theories of the prosecution as reflected in the evidence before the grand jury, which filed it, nor may an indictment or superior court information be amended for the purposes of curing legal insufficiency, and this is legally insufficient.
It is legally insufficient with respect to the charges that were ultimately dismissed. It is not legally insufficient with respect to the charges that were ultimately put before the jury.
I don't think there's a distinction there.
Well, Your Honor, I would just argue that entire section of the CPL has to be read in line with the common law rule that this court articulated in Miller, which is that it's the facts of the indictment that make out the crime. And as long as the defendant isn't prejudiced in any way, in fact, multiple times on the record, defense counsel conceded that this was probably the correct course of action for the court to take. Of course, did preserve his objection, but multiple times noted and in fact, didn't even bring it to the court's attention until well into trial, and there are multiple moments on the record where everyone seemed to agree that the defendant was not being blindsided by any of this because that lesser included offense can always be submitted to the jury.
What about the case of People versus Perez in the Court of Appeals?
I'm not familiar with that off the top of my head, Your Honor. I would have to...
Well, in that case, I believe there was a greater, and then a lesser was included at trial. The defendant was acquitted of the greater and convicted of the lesser. But then on appeal, the Court of Appeals rejected, reversed, and it had to be retried on the lesser. They weren't able to just go and amend the indictment.
I'd have to read that case, but I think it would depend on what element of the greater offense was found to be defective in some way or perhaps not proven out at trial.
They weren't able, in other words, they weren't able to just amend the indictment that had the lesser on it in the first place and go to trial on that initial indictment, even though it had the very charge that they were reversing for.
Again, Your Honor, I think it depends on what element is missing. If there is some element that is not proven out that pertains to both offenses, then that may be a problem if the people then later try to charge a lesser included offense. Here, the indictment made out all of the elements, and that is what this court has consistently held is what actually articulates the crime, as long as the defendant is not prejudiced in any way, which he clearly was not in this case. And for that reason, those two counts should be affirmed, and unless there are any questions pertaining to legal sufficiency, we'll rest on our brief.
Thank you.
Thank you.
Briefly on rebuttals, Your Honor. I just want to clarify, the Court of Appeals has held that for an indictment to be sufficient, all the material elements of the crime charged must be alleged, not all the material elements of a crime. It has to be the crime charged. Now, the people attempted to charge Mr. Winston with assault too. They failed to allege all the material elements of that. Now, the respondent contends that there's no case that's perfectly on point to match these facts, but there is. People versus Toodles is nearly identical to the facts presented here, and it was before this court. Apart from the crimes that the defendant was accused of or convicted of, it is identical to those here. In that case, they omitted a material element, irrespective of the fact that the allegations alleged the lesser included. This court still held that it was defective, and because it was defective, those two counts had to be dismissed. The CPL's language is very clear. Additionally, the respondent cites to Mueller. I also just want to highlight that that case did not involve a defective indictment. It only stands for the proposition that a court can charge a lesser included, which we are not disputing, but only if the original indictment was not defective. Thank you.
Thank you. Thank you both. Rank versus rank.
Good afternoon, Your Honors. My name is Michelle Weiss. I appreciate the court's allowing me to appear pro hoc vice on this matter. I represent the plaintiff, Kim Rank. Because everybody on this case is named Rank, I will refer to my client as Kim, her sister as Linda, and her father as Richard. The appeal that we are prosecuting here is whether or not the Supreme Court erred in denying a motion for partial summary judgment, finding that Kim Rank was, at the time the company was formed, meaning the company Sequin and the company Cookie, she owned 33%. She was made and given a 33% interest in that company.
Counsel, wasn't Kim supposed to pay approximately $100,000 for that 33% interest, and she never did pay into Cookie?
Your Honor, that's an interesting question for the following reason. Kim had no knowledge that the company was set up, this way, that she was given a 33% interest when she, in fact, had bargained for a 50% interest. The documents were never sent to her. She was never given the opportunity to sign the document. And the document itself, which is a subscription agreement, specifically says that the payment will be made when it is requested by the company, which obviously the company never requested her to make any payment.
The company was never actually formed, right? Because there was another participant, Wong, who was supposed to be part of Cookie, and then they backed out. So Cookie was never actually formed.
Absolutely it was formed, Your Honor. We've attached to the record the certificate from the state of Minnesota in which the company was registered as a company in Minnesota. It remained in existence until 2009. It was involuntarily dissolved. It was then reinstated and again dissolved in 2014. In addition, Sequin was also formed at the same time, and in the documents that were presented, created by Linda, which are all admissions against interest. In those documents, it shows that Sequin transferred 300,000 membership units to Sequin, and it was owned to Cookie, and it was owned by Cookie. All that happened at formation. Both companies were formed. Sequin was owned by Cookie. Cookie was owned by 3 individuals, each with a 33% interest. All of this was done by Linda. Tax forms were filed, again showing the membership interest. One of the tax forms was also signed by the father, Richard. None of this was presented to my client. My client knew nothing about this. It was simply done by Linda. And Linda, in doing that, must accept the consequence of her actions, which is she made Kim an owner of the company she was a one-third owner of, and her father was a one-third owner of, which owned 100% of Sequent. The investor, okay, this was all done in between November 1st and November 3rd, 1999. They negotiated with the investor, Mastermind, through February of 2020. That investor was supposed to buy 40% of the company. That investor backed out. So Sequent's Cookie 60% ownership, Sequent's ownership, Sequent's 300,000 units became 100% of the issued units, and Cookie became the 100% owner of Sequent. And that's the end of that story for the simple reason that once you form the company, and once Kim is vested with ownership interest, when you want to change that interest, you have to have a shareholders meeting. You have to call a meeting, provide a notice of the meeting, and tell your shareholders what it is you want to do, and have a vote.
So wait a second, counsel. Was there any subscription agreement for the shares of Sequent?
I'm sorry?
Was there any subscription agreement for the
Yes,
shares?
there were 3 subscription
Any
agreements.
signed, executed subscription agreement?
Yes, one by Linda, not one by Richard, her father, who obviously...
Executed by everyone who you're saying now. I mean, there are documents that are partially, I'm talking about one that's executed by all the people who you are saying are shareholders.
No, because...
No, so there's no document that has everybody as a subscription, right?
But, Your Honor, the reason my client wasn't
I just
involved...
want to get that fact clear in my head, because I felt like the way that you were saying it was that there was a signed subscription agreement by every party and everybody, and that subscription agreement had your client as a shareholder.
So, Your Honor, my client was deceived.
I know,
not given
I
up.
hear
This is
what
the
you're saying.
constructive
I'm
trust
just
claim.
trying to figure out whether or not it is true that there is not a signed subscription agreement.
There is not a signed
Okay.
subscription agreement by my
First tax
client.
return, who's listed as the shareholders of Sequent on the first tax return?
The listing on the tax form is Linda Rank, 334 shares, Richard Rank, 333 shares, Kim Rank, 333 shares.
On the first tax form in Sequent's first tax form?
No.
I thought it said 50/50.
This was the SS4 form.
I'm talking about the first tax reform that's Sequent, which you are seeking now to be a third owner, correct?
A third owner? No, we would be a third owner of Cookie.
Of Cookie, I'm sorry, which you're saying is an owner of Sequent.
Correct.
Who,
There's no dispute
who
about
does
that. They admit
Sequent
this.
list
This is all
as
admitted by the plaintiff, by
okay.
the defendants.
Is Cookie listed as a share? That's the easy question.
No, Cookie is listed as the owner of Sequent. That's
Is
in the tax
Cookie
form.
listed as the owner, as one of the shareholders of Sequent on any of its publicly filed forms?
I'm sorry, Your Honor, I couldn't hear the question clearly.
I know, this is so difficult. Was Cookie listed as a shareholder of Sequent on any of Sequent's publicly filed tax forms?
No, Cookie was the owner of Sequent shares. It wasn't
So
the other way around.
how is it that you think that you're entitled to summary judgment?
Because, Your Honor, there is no dispute that Sequent was owned by Cookie.
There's
Cookie
no
was
dispute about that?
Pardon me?
The defendants don't dispute that?
Well, they claim that that my client isn't an owner.
And you
They
have
are
no
the owners.
documents, right? It's all everybody's, they claim one thing, you claim another thing, and there are no documents that are supporting at least your version of what happened, right?
Your Honor, it was a fraud from the beginning.
I'm not doubting your claim, I'm doubting your right to summary judgment. That's it. That's all I'm saying. You've
Your
appealed
Honor,
the denial
I
of
understand.
summary judgment.
Your Honor, I understand.
Thank you.
May it please the court, Fred Bronstein for the respondent appellants. I'd like to briefly address, I want to say Ms. Rank's appeal, but I want to say Ms. Rank as opposed to Kim, just out of respect, but I do understand there's a lot of ranks. But I want to briefly address Kim's appeal and then move on to our cross appeal. So for clarity with respect to these corporate documents around the mastermind deal, originally Sequent was conceived it would be 60% owned by a company, Cookie, that Ms. Rank would then own a 1/3 interest in, and then there'd be a Hong Kong investor that would own 40%. What certainly happened is that Cookie and Sequin were formed. There are documents that were filed with the Minnesota Secretary of State that are in there. The originator, John Levy, appointed board members to both of those entities. Everything that happened since then, there's no evidence in the record that it's filed or that things occurred. Most significantly, if you look in the record at 207 to 214, these are the resolutions of Sequin and Cookie that would have authorized any action in order to distribute these shares. So Sequin had a resolution that would have accepted money from Cookie and Mastermind to become owners of Sequin. Those documents are not fully executed, meaning they're supposed to be unanimous board resolution. There's no evidence those things occurred.
The plaintiff's going on a theory of constructive trust, right? That she was deceived. And so, yeah, maybe the documents aren't going to prove a breach of contract or a breach of fiduciary duty, but there's a claim for constructive trust, and the father's got a codicil to his will that says, I'm holding the shares for my daughter.
That's correct. So I'd like to...
there it is. There's the issue of fact. Is he holding the shares? Is there a good constructive trust claim because he's holding... There is a document, it's not just in her imagination, where her father says, I'm holding the shares for you, right?
What that document means, there are issues of
yeah, exactly. Yeah. So you're not entitled to summary judgment either, correct?
No, that's incorrect. And I'd actually, on the statute of limitations point, which you're pointing me in the direction of, I'd refer the court to matter of Hollis, which I think is almost
well, so this court has found in a previous appeal that there was an issue of fact.
At the motion to dismiss stage.
Doesn't matter. What has changed between now and then? What have you put up that says there's no more issue of fact?
The full record on this case. So immediately.
Yeah, now, point specifically to what you put up. I've eliminated all issues of fact as to whether or not the father is constructively, in a constructive trust holding. Did the father put in an affidavit?
He did, yes, it's in the record.
And he denies it?
He denies that he ever made this promise to Ms. Rank.
So he denies that he made the codicil?
No, he doesn't deny making the codicil. But if you look at the record in this case, specifically correspondence between the parties immediately before and immediately after the codicil, there is...
Aren't there issues of fact? He has an official codicil to his will. It's not fake. He didn't write it on a napkin. And now he's essentially repudiating that, correct?
No, he's not.
Or denying the effect of that.
No, he's actually not. In the codicil, what he is saying, and there's deposition testimony about why he wouldn't sign these other documents that would be more clearly say that he is holding a 50% interest. The reason he wouldn't sign those is because at the time of the codicil, he hadn't made up his mind as to how many shares that he wanted to give Ms. Rank. He doesn't deny that he ever had an intent to give her something, but whether or not he wanted to affirm a contract which he denies existed, the codicil doesn't speak to that. And this is where I would refer the court to matter of Hollis. In that case, this is a summary judgment case from the Second Department. The debtor said, I have every intention of paying this debt, but the claim was dismissed at summary judgment despite that statement because of two other statements, one of which was in a subsequent communication and one of which was within that communication, that there are some mitigating circumstances I'd like to discuss, and I just want this process to be fair and not arbitrary. Here, the codicil is inconsistent with the debt at issue. The debt that Ms. Rank claims is that her father is holding this interest as a trustee and trust for her in all distributions. The codicil, later on in the document, treats it as Richard's personal property, but then following the codicil, Ms. Rank's response is, this isn't enough, this doesn't recognize our original agreement, would you please sign something recognizing this original agreement? And Richard says, no, I'm not signing that because that's not, I hadn't made up my mind and this isn't what I intended. So that's, with the existence of that evidence in the record, under matter of Hollis, summary judgment should have been entered dismissing the claims as untimely.
Thank you.
Briefly in response, there is a huge difference between a statement which begins, I have every intent to, from a statement that says, I am holding an ownership interest for my daughter. Those are two different statements. So one is an intention, the other is a declaration of his position as a trustee holding an interest. We want to argue about how much he's holding, we'll argue about how much. What was Kim's objection? Kim's objection was that she wanted a different writing that was more specific, but he said no. In fact, in their brief, they write that Mr. Rank gave her this document to appease her because she had been dealing with her family for many years to try to get her share of the company, which was 50%, because she was the one who knew how to run this business. Nobody else knew how to run a jewelry business. But I understand the court's ruling, or not, the court's questions. And so for the purpose of the summary judgment, I do not believe that there's any basis to grant a summary judgment on the constructive trust claim.
Thank you.
Thank you.
Thank you both. People versus Robert Davis.
May it please the court, Alma Gonzalez, Center for Appellate Litigation for Mr. Davis. I'd like to focus my time on point 2 regarding the lesser included offense, mostly because it involves similar facts to point 1, but I can also address the sentencing point if your honors would like. With respect to point 2, reversal and a new trial are warranted here because the lower court erroneously denied the defense's request to charge criminal trespass as a lesser included offense. There was a reasonable view of the evidence that Mr. Davis didn't have an intent to commit a crime when he entered inside of the apartment by a vehicle of him falling inside.
Did he have a weapon with him? He had a gun, correct?
Correct, he did.
Okay.
Yes, and that's really...
He was wearing a mask, right? This was pre-COVID, I think, right?
He
was indoors, but he was wearing a mask, right?
Yes, I think
it was a disguise. Pre-COVID, he falls in. You're stating he fell in, but he did have a weapon. And your argument is that there's no reason, that there was a reasonable view of the evidence that this was simply a trespass?
Well, that was, the gun, whether he entered via the gun or falling is really the issue in this case.
Wasn't the gun the first thing that entered the apartment?
That's what we don't know exactly.
Well, that's what was testified to, wasn't it? That he put his hand in with the gun was pointing.
One person did. The complainant testified as to that.
Is there anything to contradict that?
Well, it is contradicted by the other witness's testimony, which in her story, that didn't happen at all. The way that the gun was first displayed was that the complainant's mother opened the door, and immediately the man that she had been speaking to, not Mr. Davis, the man that she had been speaking to, pointed a gun at her. We don't know if it crossed a threshold at that point, yes or no. But they
So you mean Mr. Davis didn't intend to rob them, but the other people did?
Well, the other people entered after Mr. Davis was slashed and was inside of the apartment. Presumably, they were trying to go and get him out of there. Which is what ended up happening. But the people presented two completely different manners of entry here, and that's really the question. And when we evaluate a lesser included offense, the evidence is supposed to be viewed in the light most favorable to the defense, and in this case, that would have meant one, discrediting these two witnesses, or crediting some parts and not others, and that's what the defense was asking.
Can we take it all together? The mask, the disguise, the gun, the ransacking of the apartment. can we look at that as well in terms of not supporting a reasonable view of the evidence that it was a trespass?
You could certainly consider those factors, Your Honor, but the intent that matters is the intent at the moment of entry. And if he fell inside of the apartment, when you fall, that's by happenstance. That's not necessarily because you are intentional.
When you're pushing a door and somebody else is pushing against it, and you overtake them in your strength and push the door, and they fall back and you fall in.
Well,
That's not.
it wasn't necessarily.
And on top of that, I think the other individuals were kind of pushing with him, right? He wasn't just doing it alone. At least that's what the testimony is, right?
No, so the testimony, it wasn't testified that Mr. Davis himself like bum rushed the door. So
Right.
He falls in after he is stabbed by the complainant, and then that's when the people are sort of panicking in the background. And
When is he stabbed by the complainant? At what point is he stabbed by the complainant?
I am not really sure.
Well, he wasn't outside of the door when he was stabbed by the complainant. The door was locked, right? Wasn't there testimony that they came in saying they were UPS? And so the door was opened.
Correct, yes.
So my understanding of the facts, correct me if I'm wrong, is that he opened the door ajar, it's chained, and then the gun pops in, and then the complainant has a knife in his hand, and he's sticking it outside where the door is ajar, and just flinging it, and that's where the defendant gets cut.
No,
that's what the
I'm not sure if the door was changed or not. That was never testified to.
Okay.
But in the complainant's version of the events, he goes to the kitchen to get a knife. As he's walking back to the door, the mother opens the door. A conversation continues to ensue. They're not aware that he's behind the door. And then once he says something and the complainant is able to see through the people that they're alerted, that's when he starts to sort of stab around. In the girlfriend's version of the events, she is standing behind the complainant at that point. As soon as the mother opens the door, the guy, not Mr. Davis, points the gun at her and says, "Here's your package." So they're completely two different versions of the events.
So if the complainant had not stabbed one of the individuals who was banging at the door, who had a gun and was masked, then the defendant would not have fallen into the apartment and therefore caused the trespass.
Presumably, or, it could have also happened that Mr. Davis would have fell backwards and then there wouldn't have been an entry by him at all.
I don't know, because it's enacting a concert, but whatever.
Okay.
Thank you.
Thank you.
Good afternoon, Your Honors. Samuel Goldfein for the people. Just very briefly, the fact that defendant was stabbed and fell as he was trying to forcibly gain entry into this apartment does nothing to undermine the fact that he was trying to gain entry to the apartment. The evidence is very clear. There's surveillance video from the moment that defendant's accomplice snuck into the building.
Yeah, he's gaining entry into the apartment not to say hello. I mean, there's something else going on, right?
Absolutely, Your Honor. They're dressed.
He's not coming in for a cup of tea.
Absolutely not. And the only real piece of evidence that wasn't discussed just before was the fact that they tried to enter this apartment twice. The first time they were stopped at the door. Jennifer Saldana didn't open the door for them. They were asking for somebody who didn't live in the apartment. They went back downstairs and committed a series of crimes by breaking into Dela Cruz's mailbox, getting another piece of mail, and then trying to break in for the second time. So their intent is on full display. They were here to commit a crime, and I don't think anything has suggested otherwise. The fact that he slipped while fighting at the door doesn't make his entry unintentional. It was planned. It was intended from the moment they entered the building. I'm happy to answer any questions about anything else, but otherwise, I rest on my brief. I ask that you affirm.
Thank you.
Thank you very much.
I do want to clarify that, when the others were trying to gain entry, at the point when they tried to gain entry, it was when Mr. Davis had already fallen and was inside injured. And they did have multiple opportunities.
This is the second time that they knocked on the door. That's correct that the prosecutor, the respondent mentioned that. I mean, the first time they didn't gain entry. The second time they went back. It's like, persistence, I guess you can describe that.
We're not trying to claim that there was not some sort of criminal activity afoot here. We're simply saying that this element for this particular charge was not met. And, they had opportunity once the mother opened the door.
You said that you're not arguing that there was no criminality, you're not arguing that there was no criminality afoot. I mean, that's the whole part. You're arguing that there was no intent to commit a crime when they were trying to enter the apartment.
At the point of entry, correct. But if he fell by happenstance, that can't be, you can't have an intent in the moment that you are falling by
You have to
happenstance.
find that there was some innocent activity, there was something innocent on his part, and not in order to commit a crime. And again, when you look at everything taken together, even in most favorable to the defendant, I'm not really clear how you can find that there was innocent activity.
Well, he could have been convicted of criminal trespass, which, would have taken into account the fact that they tried to break in and the fact that, they did not live in this apartment building. That charge would have taken that into account. And I would like to note that,
Except that he had a mask, a gun, and then the apartment was ransacked, right?
Correct, and we don't know if they showed up because they wanted to threaten the people inside. They had an opportunity to bum rush.
That would still be a crime.
Which would still be, but we don't know if at the moment that he entered, that was their intent, because we don't know if he fell or if he put his hand through the door with the revolver, and they had multiple opportunities to bum rush this door when the door was opened by an elderly woman, and they didn't. In the complainant's conversation, they continued to speak.
Thank you.
Your Honor.
Thank you both. McMahon versus Cobblestone Lofts.
Good afternoon. If it please the court, my name is Joe McGovern. I'm with the firm of Wilson Elser. I'm glad to be here today representing the appellant, Cobblestone Lofts Condominium. This is a case of contract law, and this court has always been considered one of the premier appellate courts in the land, not just because it has the best courthouse, but because the world comes to New York to do business. And that's why upholding the law of contracts is important. Here, there's no question that the plaintiffs in this action have withheld their common charges for the condominium for 8 years. They're now in arrears for over $1 million. And this court has already ruled that there is no merit to their claim that they were entitled to an abatement of common charges. At the close of discovery, Cobblestone moved to amend its answer to assert additional contractual defenses and for summary judgment on the defense of failure of consideration, not lack of, but failure of consideration. The lower court erred. They conflated this contractual legal defense with an equitable remedy rescission of the contract. Nowhere in our motion papers did we ask to rescind the contract. We merely brought up that the plaintiffs, by breaching their part of the contractual bargain, cannot pursue a claim for a breach of contract, and this is the remaining claim in the case. We made out our evidentiary burden. We proved that this was a bilateral contract, that the plaintiff's obligation were to pay their common charges and assessments. Cobblestone's obligation was to maintain the building and run it. You can't do that without money. And we cited to some pretty good case law. Kocher versus Edelblut is a Court of Appeals case from 1928, but still good law. And the basis of the failure of consideration defense is that if you're in breach of the contract yourself, you cannot maintain the breach of contract action.
Who breached first?
I'm sorry?
Who breached first?
Well, the plaintiffs will claim that the defendants breached first, but the failure of consideration defense negates that argument.
You know, when you say failure, I know you're saying that you didn't mention the word rescission, but ultimately when you say failure consideration, you're basically saying the contract doesn't exist, right? Because there was no bilateral contract. Every contract has to have consideration. If you're saying that they failed, there's a failure of consideration, there was never a bilateral contract. So although you didn't say rescission, you're basically, that's the end result, right?
Not necessarily, Your Honor.
Oh?
Yes.
Then I got to go call my contract professor.
Well, rescission of a contract when there is a failure of consideration is a remedy. But the failure of consideration goes beyond that. It's, you can either rescind the contract, you can be excused from performing your obligations, but
Well,
most
that goes back
certainly.
to Justice Weber, who breached first then? Then that's the other issue then. If you take that tack, then it goes to her comment, who breached first? Where if you take the first tack, you don't get to her comment, you don't get to her concern.
Well,
did you follow that?
If you read Williston from the 1920s.
Oh, I haven't read Williston in a long time. Yeah. I'm too caught up with the Court of Appeals in the First Department cases.
Yeah.
This is the third time, right, that this case has been before us. Because I sat on one of the appeals in this matter as well. But I still don't understand what the issue, I mean, is there a rescission? Is there not a rescission? What is it that you're claiming?
No, there's not a rescission because we're still, Cobblestone is still obligated to repair the common elements of the penthouse unit.
And you have a contract.
And we have a contract, and we're doing that.
And aren't you saying that the failure of consideration is essentially another word for they breached first?
No, that's not what we're
That's the
saying.
only possible way you could still have a failure of consideration claim without claiming rescission. And yes, I read Williston constantly. So it just you can't do it both ways unless your failure of consideration claim is part of breach of contract.
Well,
and their claim is, no, we have no obligation because you breached first. Correct?
that's their argument. I don't believe it's a correct argument. Corbin is also in agreement.
That's a trial issue. But I'm just saying that's the issue. And you're saying the court should have granted me summary judgment on my failure of consideration claim, but I'm not seeking rescission. So if you're not seeking rescission, what you are essentially saying is that there was a breach of contract because of failure of consideration. And the other side is basically saying, no, there wasn't because you breached first. Is that not correct?
It's an incorrect argument, and
what's incorrect about it?
Because it doesn't matter who breached first. We're now in a position where we're going on for 8 years with no common charges being paid, and they've pretty much made it clear they're not going to pay these common charges, and therefore, under the case law we cite in our brief, they're not entitled to maintain their breach of contract action.
So then why don't you just go to trial? That's the whole, isn't that the good result? Go to trial, you're done. You've moved for summary judgment, you filed your note of issue, go to trial.
There shouldn't be a trial because the law is clear that they're not entitled to maintain the action when they are in breach themselves. Even if the defendants breached first.
You think that's the law, that if the other side breaches first, I still have to comply with the contract?
Yes.
Okay.
And there are cases cited in the brief which stand for that proposition.
Okay.
Thank you.
Thank you.
May it please the court, good afternoon. Michael Gordon, Gordon Law LLP, for the plaintiffs' respondents, the McMahon family, Shane McMahon and Marissa Mann, and their 3 infant children. 2 points. Number one, nowhere in their brief, either in their primary brief or in their reply, and nowhere here today did I hear any response to the point that Justice Getz made below, which is that when you have an equitable defense such as failure of consideration or rescission, and I beg to differ with my colleague, but rescission is all over their papers. On page 16 and 23 of their brief, they write, the failure of consideration gives the disappointed party the right to rescind the contract. In their memorandum of law below, they made essentially the same argument at page 3469 of the record. The failure of consideration gives the disappointed party the right to rescind the contract. They will have the right to go to trial. As soon as we get a courtroom and we can get in there and try the case, we'll try the case. And they have their remedy at law, not just in this case, but in the separate case which we cite in our brief, in which the Cobblestone is suing my clients for the very common charges that they are referencing here in this action. So they have their adequate remedy at law. If there are no questions, I would rest on my brief.
Thank you.
Thank you.
If one looks at the, any treatise on equitable causes of action, you don't find failure of consideration. It's a strictly legal argument from the law of contracts, stemming from the law of merchant, stemming from Lex Mercatia. But here's the situation, Your Honors. Allowing plaintiffs, well-funded plaintiffs, to withhold their common charges from a condominium or a co-op, it just threatens the very idea of this form of ownership. And lots of people have joined the middle class because of this. It's an ability to own a property interest and acquire equity, and you're not in the trap of paying rent to your landlord and having no equity ever in your life. You can't run this type of an operation when one party says, no, I'm not going to pay you anything and I'm going to sue you for breach of contract, even though I'm in breach of my contractual obligations. Anyway, thank you very much. I appreciate the opportunity to be here.
Thank you. Thank you both.
What time is it?
Isn't it amazing? I think it's the most beautiful courthouse.